on memo.
Candidate this matter is sent.
28 ଥିଲା 28 ରେ କୋର୍ଟ ହେଲା 28 ଦିନ ଥିଲା ସେମାନେ ଆସିଲେ ମୁଁ ଅଧା ଡବଲ କରିଦେଲି ମୁଁ କୋର୍ଟ ଆସନ୍ତୁନି
Today they have come.
ଆସିଛନ୍ତି
Bring in special notice and finish it.
highly obliged
The parties have come. Why to harass them?
well
2 o'clock you come.
2 o'clock.
Bring them.
My lord, one out of same occurrence and self-same fact, two criminal proceeding has been initiated. In CT number 2776 of 2013, the trial already commenced.
Right.
And now, my lord, in one CC case, on the self-same fact, on 16th, that has been fixed for evidence, my lord. So I have prayed for quashing of the second proceeding, which is not maintainable in the eye of law. The same occurrence, self-same
So
fact.
why have you waited for such a long time? Why you
My
are
lord,
coming in the last hour?
as all the petitioners are poor villagers, my lord, farmers. They have released on bail, my lord, anticipatory bail.
The ICC
They are-
case might have been initiated long back.
2015, my lord.
15. Now you are
Now-
coming and saying it's so urgent.
As the evidence,
2024. Kindly appreciate.
only yesterday I have filed, my lord.
That's right. That's the problem. You
I
give
pray-
it, we'll see how can
I
we
pray on
complete.
15th, my lord, I will remove the defect in the meantime.
You have not removed all.
No, I will
You have not one problem, many problems.
yesterday I have filed, my lord. I
Okay,
will
give
remove
it,
the
we'll see.
my lord.
But this matter was specifically fixed on 5/4/2024 at 2 p.m.
What do you want? Give it.
Pardon to-
See, the priority basis, we are trying.
I'm pardon to make mention, my lord, one CRLNC 853 of 2024, my lord. The offence alleged under section 376 of IPC, my lord. Both the party, they have already married, my lord, compromise matter, my lord. Can this matter taken up tomorrow, my lord?
Much better.
Well, date may be fixed, my lord, both the
Date
party
will
will,
be fixed, you don't worry.
both the party will be appear, my lord.
Yes.
Lordship,
Please
Another-
be in touch with
Lordship,
one day, one matter.
Another matter, same compromise.
Do it tomorrow.
Lordship,
Because I will not give any relief to you because one matter I have given, so tomorrow you will. Okay?
Liberty to mention, Lordship, this is a lady Punjab bank manager of Punjab National. She sanctioned a loan of 5 lakhs rupees. One company director took that money. Now the sanctioning, she filed an FIR saying that due to manager
Why do you come with all difficult cases?
Lordship, because police is
Take Mr.
she's a lady.
We'll see.
My lord,
Accommodate.
my lord, order of cognizance and enter criminal proceeding is under challenge, my lord.
Keep the news.
Pardon to mention, my lord. My lord, from the list, item number 13 and item number 104, I pay for 1 week after, my lord.
Is after notice or fresh matter?
Item number 18, 13 is the fresh admission matter, your lordship.
38.
Item number 13, 13.
Fresh matter? Adjourn.
And item number 104 is coming under the head of hearing, your lordship.
That is revision.
Yes, your lordship.
Wait, revision.
Because the lordship we have not prepared.
We'll accommodate. Take it and we'll accommodate, but don't worry. We'll see what is the matter.
Pardon to mention.
Who knows that I may acquit your client today in your absence also. So,
Pardon to mention, my lord.
My lord, item number 76 and 77. On behalf of SK Das, my lord, she is yield, my lord. Already taken to,
revision.
no, my lord. After notice,
Fresh
not-
matter. Fresh matter.
Pardon to mention, my lord. Item
76 and 77, my lord. Two matters.
677.
I have already taken consent to petitioner, my lord. Oblige, my lord.
Pardon to mention, my lord.
Same page, item 72. There's 4-5 matters are tagged up, and they are directed to state to file a response, giving details of the individual role of the persons, and thereafter to file a response by us. Till date, they have not said.
So, with a chance, matter. Take it. We'll adjust. Intermediate will continue, but send your junior so that I can give.
Pardon to mention, my lord. My lord, from the list, item number 7, my lord, praying for an adjournment, my lord.
7.
Yes, my lord.
7 will come within 7 minutes. Why can't you wait? You are a young.
My lord, another 2 item is there, 14 and 50, permitted to withdraw, my lord. I have already
14
filed.
and 50 withdraw.
7, my lord.
7, please wait. I'll take it up right now.
My lord, another police case is there, so that's why
Okay,
I
7 adjourn.
oblige, my lord.
Belgium there. Belgium.
My lord, item number 80. Matter is pending before mediation center.
80.
80.
awaiting
Any-
mediation, adjourn.
My lord, item number 54 and 61 on behalf of Mr. Amit Prasad was due to his illness of 1 week.
54 and
61.
54 and 61.
Pardon to mention, Your
1
Lord.
week after or 2 weeks after?
I think he has some. Help.
Pardon to mention, Your Lord.
Obligement.
Pardon to mention, Your Lordship.
Yes. Yes.
CRLMC file on dated 6/3/2024 not yet been listed, Your Honor.
You just
Sir,
give
let me-
your slip, we'll see. Huh? You give your slip,
File-
we'll see. Give your slip. Give the memo, we will see.
Okay.
Okay? Give the memo. Yes.
With my lord's kind permission, my lords, I had mentioned a matter last week on Friday for an urgent listing, and my lords had allowed it for Monday. But my lords, we came to know that there is an administrative order by which matter which is already given a date cannot be preponed. So therefore, my lords, I am taking out one interim application. My lords, I'll be filing it today, my lords, and I'll giving the number.
You
My lords,
file it, mention it will be listed. Don't worry.
my lords, may I request to keep this matter tomorrow, my lords?
You have not filed the application, how would they list?
My lords, I'll give the number within few minutes, my lords.
At 2 o'clock you mention, file it and mention at 2 o'clock, I'll get it listed tomorrow. If it is
Okay,
very
my
urgent.
lords. I'm authorized.
Okay. Miscellaneous matters first. Miscellaneous. Sir, which is your matter, sir?
Below,
Yes.
item number,
I'll take both the matters.
item number 23.
23, okay.
If I only show it to my lordship,
23 first take up.
I'm deeply obliged. If my lordship would only see this matter, I have asked for a quashing of a proclamation.
1 minute, sir. I'll just take it out. Yes. 23, yes, sir.
I'm only providing the certified copy.
What is this matter is about?
My lord, the proclamation has been issued against me.
80 to 83.
Yes. My lordship would just see the proclamation at page 6. Running page 6.
6 up. What?
6 of my brief. Notice.
This one you have given?
Now, this is the order.
Okay.
My lordship sees the notice.
6, okay.
Notice, second paragraph.
Yes.
The proclamation is hereby made to so and so before this to answer the complaint on 23/3/2024. Order has been passed on the same day. How? If the proclamation notice, this was incorporated, backdated. All the three accused, then my lordship sees page 9.
But you tell me one thing. When are you going to?
It was not there when I checked the records. He has incorporated this thereafter because I took away the notice.
But you forget about everything.
No, I'm forgetting about
When are you going to appear? You tell me.
any day. My lordship, any day I say, my lordship,
I'll record your undertaking. Go and appear.
yes, my lord.
Law will take its own.
And my lordship would pass orders of bail. Because all the three accused have been released on bail. My page 2. My lordship says page 2. Running page 2.
2 of this.
All three have been released on bail. Running page 2. Mid portion. Paragraph 2. After 4 lines.
Order dated.
Page 2, paragraph 2.
Order dated.
Order dated. All by the magistrate.
Which order you are?
Argument. All the family members called upon the neighbors to escape so and so.
Where are you reading, sir? I'm not able to get it.
Page 2, middle portion.
In the brief.
In the brief.
The one which you have given or from the file?
Brief.
File, okay. Page 2.
Page 2.
Okay. Page 2. Page 2 is your petition.
Yes, page 2.
So, from petition you are reading. Okay. Yes.
All have been released on bail. All the three. There are total 4 accused.
Where are you reading?
Middle portion.
Okay.
Basing on the report, so and so PS number so and so was registered for the offence punishable under 457 and 394. During the course of the police examined and witnessed so and forwarded them and were released on bail by the learned session judge on 30/10/18. BL disciplinary 2 other accused.
Let me consider the petitioner Mr. Ryle and consider the petitioner submits that on 30th October 2018, the petitioners were enlarged on bail. Then when you defaulted, thereafter you
All the co-accused were released on bail. There were 4 accused.
What about you?
I had no notice because page 9, no address is there. The culprits were unknown. My lordship sees page 9. Page 9, all the 4 accused, they said unknown. My lordship sees just page 9, 8, running page 8. Running page 8, my lordship sees running page 8 at the top.
Unknown.
Unknown, all unknown.
But how about the other people?
My lordship sees no summons were issued. 41B, no summons were issued. Straight away, how can warrant be issued? Violating 41B, A and B. So if my lordship would only fix the terms and conditions and release me on bail.
Like
I mean,
release, see, in the 482, I can't do it. You
No, what?
I'll protect you to the extent that you will be appearing in a particular date. Till then, no course of action against.
No.
To
Why I say?
I can't. No, see, in 482, I can't give bail.
Why? Because if my lordship would take the order.
If I can understand, if you were on bail, then I could have restored that.
No.
But you are never in bail. I can't restore it.
No, I will tell you. The lordship says 82. 1 sec. I take my lordship for 82.
Yes.
Running page 82 of the Criminal Procedure Code.
That there I am passing it, and I am relegating you to the court below to move appropriate application, and you have a parity. You have parity with other accused persons. I'll record it. I'll record it. You have a parity. Why?
I would only say fix the term. What?
I'll just see. I'll try to balance both the things. Yes, my petition. All the co-accused persons have been enlarged on bail by the Court of Sessions. In the FIR, the FIR was registered against the unknown person. The petitioner was never issued any notice by the police, as a result of which he was unaware of the proceeding, unaware of the present proceeding. Due to his default, NBW was issued by the court, by the learned Sessions Court on 23/12/2019. 23/12 it is written. NBW 23/12/2019, and subsequently process under section 82 CRPC was drawn up against the petitioner.
On 23/2/24.
On
23/2/24.
The proclamation notice dated 23/2/2024.
And the order is also from 23.
Indicates that he was supposed to appear before the court on 22/3/2024.
Correct.
Whereas on the same day, the proclamation order was confirmed. Therefore, he is agreed. Mr. Rai, learned counsel for the petitioner, submits that submission on instruction that his client would be appearing before the court below on or before 5th of May 2024, and move appropriate application and avail remedy under law. He further states that he would be moving application, taking all the grounds, including the ground of parity, for the purpose of grant of bail with the aforementioned.
The court will do well to.
And it is expected that the trial court shall deal with the application in accordance with the law as expeditiously as possible, preferably decide on the same day. Decide the application on the same day. Therefore, the proclamation, the impugn proclamation order dated 23/2/2024 shall be kept in abeyance till 5/5/2024, and the petitioner is given the.
My lordship will quash it also.
He set aside. set aside and petitioner is given, subject to the petitioner surrendering before
Yes,
the court
got it.
below on or before 5/5/2024 and move appropriate application.
And bail will be considered on terms of merit. One line.
That I read it, that I read it, that I read it.
My lords, I would only make a submission. I've never seen justice being dispensed in such a manner, not in my case. In all cases, and this is the talk of the High Court. My lordship has
Thank you.
come
All these things I have
as a
learned.
messiah to this High Court. Why I'm saying
Thank you very
so,
much.
this is not modern flattery.
All these
This
things,
is,
all these things
dispensation
we
of
learned,
justice.
all these things all of us learned from seniors only.
My lords.
All credit go to seniors.
One
only.
thing I will say, your lordship might be knowing, my land senior friend was arguing the case of Justice Lalit Mishra in Supreme Court.
I was opposing him.
I'm not on that.
Not on
After he came out from the court, it was the talk, who is this second Englishman?
No, my lords, I will say,
In the Supreme Court, I was opposing him.
the ninth judge bench, I've never seen an honest and sincere counsel like my lordship. I can tell you, so fair, I've never seen one.
Thank you, sir. Thank you.
Right on.
Also, who is the first Englishman? This is the second Englishman.
Still, we are searching for the first Englishman. Yes, sir.
Keep your blind.
6.
Yes, my lord. At the outset, I will say that there are other councils, whether they are present.
Yes, sir.
Sir, I am present for OP number 2.
What is this matter?
Recall of a witness.
A petition was filed on section 311 by one of the accused before the trial court, and the trial court allowed the said petition in spite of the objection from the learned additional PP who was conducting the case. And the reasoning is absolutely, there is no reflection why the court allowed. Your lordship may have a glance to the
Who
input.
are you?
I am the son of the deceased. I am not the informant. And what happened actually, just I am going to the background for better appreciation. The case was casually investigated, charge sheet was submitted.
Man, how do you maintain this petition?
Madam?
How do you maintain this petition? You are not the informant.
No, that is true.
Then
That
how do
is
you maintain it?
That is true. State is supposed to challenge this order before this honorable court.
State is laughing.
I am just giving the background how the substantial justice is going to.
There is only
affect-
one witness is recalled.
One witness.
You are the
Only
If the reason has been given, I would have no grievance. If the court
Now,
applies
even if you have a grievance, but how do you maintain this petition?
maintainability, how? I will satisfy your lordship how.
Yes, you
Yes.
just satisfy me because you are not the informant.
Yes,
You are
I do.
not even a witness.
I do understand your lordship's query. I will satisfy your lordship even if a relation of the victim can challenge a order in the superior court if it goes against the prosecution or the party who is going to be ultimately affected. That is the point I will satisfy.
How a witness which is recalled, how do you think that it will go against you? What is the prejudice?
Yes.
For the fair trial, if the court thinks that one witness is required to be recalled, it is recalled.
Recall not.
How a stranger to the proceedings?
Yes, your lordship rightly put the question. Recalling a witness is a exceptional provision. And the exceptional circumstances to be shown to the court. It is not a matter of routine. And while the court is adjudicating either allowing or rejecting, the court must apply his judicial mind and reflect in the order
But
itself.
the state is saying state is aggrieved or state is not?
A state is agreed as it appears from the order itself because the state opposes that application.
Yes, Mr. Ragada, are you really aggrieved? Or you are questioning?
The questionnaire,
You are the prosecutor.
my lord, 5 questionnaires given, my lord,
Huh?
to the, my lord, by the petitioner, my lord. And all the 5 questions, my lord, though some questions are not relevant, my lord, but if there is, my lord, the witnesses.
You are partly supporting, partly.
My lord, my lord.
My lord,
There is no.
my lord, I am appearing for OP number 2. Kindly see the page 39, running page 39.
39,
I go.
39. Okay.
the observation order part of the court.
Yes. Yes.
May I read, sir?
Yes.
It is seen that the proposed question have not been put to the witnesses by the defense
1 minute.
due to the advertence of the
missed-
hence.
1 minute. I missed. Yes.
Sir,
Yes.
39 last question.
Last,
Last para.
mhm.
It is seen that the proposed question have not been put to the witness by the defense due to the inadvertence. Hence, for just decision of this case to ascertain the true facts and the proposed question appears to be relevant. Hence, the decision cited by the prosecution are not applicable to present case. Accordingly, the petition filed by the under section 311 CRPC is allowed. Sir, only 5 questions
Sir,
has been
you
to
have
be
to
asked.
satisfy me that you can maintain this petition.
Yes.
Please satisfy me. Otherwise, I will not interfere. Because the prosecution is supporting, basically.
Sir,
Half-heartedly
sir,
saying that
only
you-
5 questions to be asked, not other question.
And I can add one more thing that these
What is posing a question to me,
Sir,
whether I have locus time
I
to
can,
file
I
such a
can, I
petition?
can, I can only say that the question at 5 questions which they are going to
Ask.
ask this witness, the relevancy of those questions will be gone into by the trial court. That's all.
That's
To that extent, I'll.
my predicament is that this is a backdoor way of demolishing the prosecution case by allowing. That's
Prosecution is
what,
happy.
Madam,
Prosecution is happy. Let it be demolished. What to
prosecution,
do? Prosecution is happy. What to do? Prosecution is saying, is laughing. Who are you?
your lordship may have a glance to the page 38.
Yes.
It was vividly objected, not only objected, but case laws were cited. Unfortunately, what are the law decided that was
Alright,
not.
but now they're accepting it. They are not making agreement. You are a stranger to the proceeding. You satisfy me. Can you maintain?
Yes. I will satisfy. Your lordship may take it on Friday or any other day. I will satisfy on that point.
Only maintainability. Maintainability
Yes.
at your instance.
Sir,
Friday.
may I submit one thing,
Yes.
sir? Sir, my senior learned senior has submitted to take some time, but may fixed a short time because
Friday.
No, Friday koile I was
because the trial has been held up for that reason.
It's a question of law. Let us see. All of us will be benefited by
Okay.
it.
It is a legal question which has been
Okay,
put
okay, sir.
to me. It is not the case. It's a legal
No,
question.
I know.
Whether a person who is no way connected with the
Not
case
even
directly.
informant. Not
Yes.
even informant. Not
That
a
is a very.
witness.
Yes.
You are a stranger to the proceedings.
In fraud, before another application that is come, my lord, which my lord.
But target the trial. That connected record as.
First, let us.
Informant has filed the application to target the case and conclude it within.
Informant also, also don't have any problem with this. The informant doesn't.
ମୁଁ କହିଦେବି ପୁରା ଏଣ୍ଟାୟାର ଷ୍ଟୋରିଟା ଏବଂ ମୋ ଲୋକଷ୍ଟାଣ୍ଡି ତାପରେ ଆପଣ ଡିସାଇଡ୍ କରିଦେବେ it is a game plan going on behind the back to weaken the case. I am not elaborating.
Okay, Friday. Right. Okay. Any senior?
No.
Yes, sir. Which item, sir? 9. Yes.
This is a case for quashing the FIR.
Yes.
Very strange case. Your lordship may kindly see annexure 1. That is updated. I am giving the certain dates. Thereafter, I will take your lordship to the fact. This FIR is lodged on 2/11/2023.
This investigation is on.
Yes. I pray that it is completely an abuse of process of law and just to harass me. That I will satisfy. If I will be failed to satisfy your lordship on that point, and when civil litigation is going on and they have lost in injunction, whether this proceeding is maintainable.
What are the allegations here?
My lord, your lordship may kindly see annexure 1.
467 for Acha.
Annexure 1, page 13.
Yes, 13.
Offense alleged 465, 467.
Yeah, all sister sections.
Yes, my lord.
Yes.
And
to 15.
Where the case is registered, your lordship may kindly see. The case is registered in special crime unit, and because the informant is a retired DG police from Jharkhand. That is the case. Now, what is the allegation? Your lordship may kindly turn to exhibit annexure 5, page 49.
They come to 15.
50.
15, 1/5.
1-5, my lord. Yes.
Allegations are there.
No, I am not taking your lordship to the allegation.
Huh.
I only, when the crime, suppose the crime is true, there is prima facie case. But if at the date of commission of the crime, I was not born, whether I can be prosecuted. After 56 years of the alleged crime, that is my case. Your lordship may kindly see page 49, annexure 5.
5. Yes.
This Hariar Ratha is the father, deceased father of the informant. And he executed this cell deed, your lordship may kindly, in favor one Bajo Mohabhai on 8/2/1964.
Okay.
Now he is dead since long.
The father.
Father. Then this Bajo Mohabhai in 1978 or 78 sold it to one Kedarnath Swami. That Kedarnath Swami, while in possession, sold it to me. Your lordship may kindly annexure 6, page 52. Page 53 is the cell deed. This is dated 14.
You purchased from Swami.
Swami. By the annexure 6.
The original owner was that.
Hariar Ratha, he sold it to Bajo Mohabhai in 64.
1964.
8/2/1964, the date is relevant.
8/2/1964.
64.
Swami. Then.
Swami sold it.
Hariar sold to.
Hariar sold to Bajo Mohabhai.
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 Then in 78, Bajo Mohabhai sold it to Kedarnath Swami.
1978. Okay, 78.
Then that Kedarnath Swami sold it to me on 4th December 2020. 20.
Kedarnath Swami.
Kedarnath
Sold
Swami.
it to you.
Yes, yes.
Okay.
Before that, your lordship may kindly see, then annexure 7, when I was born. Annexure 7, my lord.
Yes.
This is the pan card, my lord. Bottom, your lordship may kindly left side bottom. 11/8/1964. My Aadhaar is also there.
8/64. Okay.
Now, again I will submit your lordship. The cell deed is dated 8/2/64. And the allegation is that in the cell deed of 1964, his father has been impersonated and forgery has been committed by impersonating a person. No, but before this, because he is a retired DG, your lordship may kindly see that annexure 2. Annexure 2.
Yes.
Page 23. That this is the FIR. Plaint filed by the informant along with his other brothers.
Who are you? What is your name?
My lord.
Sunita Chaudhary.
My lord. 24. Copy of the plaint.
The plaint was filed. Okay.
Yes. Suit was filed on 11/9/2023.
Pertaining to the same property.
Same property, my lord. And I am a party. And now, after
what is the fate of the suit pending?
No, my lord. In this suit is pending. I have filed my written statement. There they filed an application for injunction. Status quo was granted by the trial court. Now, your lordship may kindly in appeal under order 43 rule 1 again.
39(1)(2) allowed.
No, that is dismissed.
And he have filed appeal.
Yes, I filed the appeal, and that is been allowed so that my property is protected now. On this background, whether the FIR after
let us just see what is the allegation in there.
Allegation, yes, FIR, lords may kindly see. Long page FIR and how it is registered directly.
Come to page 15.
Yes, my lord. 15.
What are they?
Sirs, with due respect, I Gauri Sankar Ratha, a retired IPS officer and resident of such and such, 70 years, submit the following lines for your kind consideration or order for registration of FIR and take up investigation along with the necessary preventive and punitive action against the above named accused who have conspired to grab our ancestral land situated in our village Kolaharango under Manchester Police Station, PS jurisdiction Bhubaneswar. Hal Khata number 707, plot number 923, area 220 decimal of Kolaharango Moja. He is one of our legal inherited ancestral property inherited by we, 4 brothers, myself, Gauri Sankar Ratha, such and such. Let Hariar Ratha, for which ROR and rent receipts are with us and we are in its possession. The land after death of our father has been mutated in our favor along with the properties by mutation case number such and such. Copy of the ROR is enclosed. we next 16. We have vast landed properties at Kolarahanga Mauja, Bhait Sabik Khata number, so 104 comprising of 6 acre 420 decimal in name of our father, let Harrier Roth. Subsequently, in the settlement undertaken by Kotak Major Settlement year 1973-74, after following due process, ROR Potta issued in the name of our father in which
Whether this Swine and
no, they are not parties, they are not accused.
what is this?
Only the witness and identifier to myself are accused.
But the case was registered, my lord, and the investigation is going on.
The prima facie, this is appears to be,
My lord, the investigation must have been substantially progress, my lord. I have to obtain the case diary, my lord. But if there is material, my lord, then in the initial stage, my lord, FIR cannot be quashed, my lord. But the investigation going on, he has to cooperate the investigation, my lord. Instead of cooperating, my lord,
are you on bail?
My lord, yes, I am on anticipatory bail.
They
tried to arrest
all the
me.
documents were
In spite of the fact of pending of the
The
civil
only problem is it is at a very threshold. There is no case against it.
That my lord, yes, my lord, yes, that I. And the
A
offense
suit is pending, injunction was declined, and then he went to appeal, that is confirmed. And something has happened in 1964, February.
55 years after.
And he is born on August 64. And if at all anything has happened with Harrier property, it might be in February 1964.
But the case, but the mutation, my lord, in the year mutation case number, mutation case number
But this is the
233%, 2018, my lord.
Why don't you give all the things to the police and the
Yeah, everything I have given. In spite of that, insisting me to submit the original.
I'll simply issue notice. Tell me what is the state.
I'll call for the case.
Simply issue notice.
Yes, yes, my
Call
lord.
for the record. We'll see. And otherwise, I will have to quash it. Unnecessary. This is arm twisting.
In the FIR, my lord, pendency of civil suit is not disclosed.
See, the FIR is how many pages? Just see. Is it bigger than the plaint?
My lord, can they show one single case directly registered by the crime branch?
Anyway, let them
My lord, yes,
notice and get this here.
My lord.
Okay. Yes.
But also notice to the opposite number 3, my lord.
Opposite party number 3. Also.
In by speed post or by registered post?
Any seniors are there, we'll finish it up. Any seniors? Huh? Yes. Okay. Yes.
May I please?
Yes.
And the FIR is under challenge matter. The petitioner is implicated in the statement of co-accused person. My lord, kindly have a glance to Annexure 3, the cognizance order.
Yes.
The charge sheet has been submitted.
What was the order passed by the coordinate bench? Let us see.
Yes, my lord. A report was called for. Order dated 26/9 of 23.
Oh, that's right. I'm reading.
CD, my lord, CD and CA call for, my lord, that has CD has come, my lord. So I will receive this.
Submit that the allegation against the petitioner is that he and one Rocky Sam were document of the auto rickshaw and which was stopped by the police on the suspicion of contraband, and when the auto rickshaw was stopped, the runaway was recovered from the rickshaw. To the new control 21 pages on 18 allegations of solicitation. There is a preliminary charge sheet.
My lord.
What about the supplementary have you filed?
Not
the preliminary charge sheet is against only that
Pavan Kumar.
Provadora.
Keeping
Probandora.
open the investigation, my lord. Final charge sheet has not been filed till yet, my lord. That about, my lord, so far the 161 statement concerned, my lord. Some of the all the witnesses stated against him, my lord. If you permit me, I will read out, my lord.
Then his submission that is only co-accused.
My lord.
Rocky Shamal has implicated him is wrong.
ପଚାରିବାରେ ପବନ ଦ୍ୱାରା କହିଲା ଯେ ଅଟୋରୁ ଖସି ପଳାଇଥିବା ଲୋକ ନେହୁର ପଲ୍ଲୀର ଗୌତମ ପ୍ରକାଶ ପିଟିସନର and ରବି ସାମଲ।
The
And all
main
witnesses
accused, the
were-
Pavan Dora is the main accused. He is the driver cum owner of the
This is
auto rickshaw.
quashing at the FIR.
My lord,
My lord.
all
You,
witnesses.
you have submitted before the coordinate bench that except the co-accused statement, there is nothing. That is the reason notice was issued. Now there are many witnesses. And
My lord,
one-
trial is going on, 7 persons already examined. And as per their testimony, the occurrence is in doubtful, my lord. Yes, I'm.
Can I go into all this thing at this stage?
No, my lord, why I'm saying your lordship has to consider it because of the woman himself. In his deposition, he said that I was in my fruit shop. Police came and take my signature in the printed format.
You may be correct, sir. I'm not saying that. You may be correct. But can I go into all these things at this stage? It's at the very threshold.
So far as co-accused, the implication and
You have persuaded the coordinate bench to issue notice only on the ground that except co-accused, nobody has said anything. Now material has come.
no other persons are eyewitness, my lord.
Rajendra Lenka,
You are run away from contraband is seized
Narendra
from the
Parida,
vehicle.
Sudhir
from where
Kumar
you
Valyar
ran
Singh.
away.
And the petitioner is no way connected with the vehicle or with the main accused who is arrested from the spot,
Anyway,
my lord.
173A is also open.
Open, my lord. Investigation going on, my lord.
No interference.
Let it be any other time. I'm submitting the deposition copies of the
I will
deposition.
give you liberty to challenge it after the complete charge sheet is filed. If,
No, because I'm not in bail, my lord. For that reason, and this is a clear case of quashing, my lord.
how can you say that clear case? You tell me if there are 161 statements are there, 3-4 witnesses have said it.
The persons stated in 161 statement, they deviated from their statement in deposition, my lord, in the court, my lord. They are saying that there is
Trial is
no
going on,
occurrence.
you will be
We are
acquitted.
not there.
Trial is going on, you will be acquitted. I can't quash the FIR like this. Trial, what is the position?
Trial going on, my lord, except the, my lord,
Trial going on by splitting the case.
whose against charge sheet submitted, only Pavana, my lord, Dora. Against him, trial is going on, my lord. These petitions are absconded and investigation going on against.
Even the official witness, the cops were denying the occurrence, my lord. Your lordship, only one opportunity may be given to me by verifying the depositions. The constables are denying that they are hostile, my lord.
But you have not participated in the investigation. 173 is open. How can it quash
That
the
occurrence
FIR?
is doubtful, my lord. That occurrence has not taken place.
All these things, who will go into?
Another
The trial court will go into. I can't go into all this evidence recorded in the trial court for the other accused person. I want to evaluate that here. You are an absconder.
They may, if the petitions to charge sheet,
Abscond,
they may say, treated against the petitions, my lord.
You want to
My
withdraw,
submission is-
you want to withdraw with liberty, or I'll write a order.
No, I want another chance to move this application.
Move, that's liberty I'm giving.
No, this application, I'll prepare another.
So simply adjourn karo. Unnecessary, these petitions will be pending for no use. Anyway, adjourn karo. Simply at the request of the then council of petition, adjourn.
Because of the submission, my
You are not on
submission is
bail.
I was not there.
You are not even on bail, huh? That's the whole
Twice, that has been rejected twice, my lord.
That's the whole issue. Anyway.
Because I was not there at the occurrence. The occurrence itself is doubtful, my lord.
Then it's a good case for bail. You go and get bail and participate. You will be acquitted. What is the big deal? I will record all these things and withdraw. Go and ask for bail and the case will be dropped. Otherwise, you will be hanging.
Your lordship, with that observation, your lordship may
That's what I'm
that
saying. I'll give that observation, and so that you can go and
move
avail
further.
your remedy.
With all my submission, that was
Yes,
observations.
everything is open. Then
And specific submission is that I was not there and they were.
Yes. You tell me whatever you want, I will record. No problem. Right now. Item 1 thila na?
Item 1.
In the present petitioner is seeking quashing of the entire criminal prosecution initiated against him. On the ground that barring the co-accused statement, no material has come on record against him.
And the women and the two constables are examined and they are not.
The trial insofar as the co-accused person is going on, and in the said trial, none of the prosecution witnesses has supported the case of the prosecution. Therefore, if the evidences are evaluated, no case indeed is made out against the petitioner. However, the petitioner petitioner has been absconding in the case. Therefore, charge sheet could not be filed against him, and the prosecution has kept the further investigation under section 173 bracket 8 CRPC open. Therefore, the petitioner seeks liberty of this court to withdraw this petition, surrender before the court below, and move appropriate application under law, raising all his contentions, including the contention. What contention you want to raise? Tell.
Regarding the trial, my lord, the deposition of the
including the contention that no material has come on record as yet against the petitioner and petitioner except the statement of co-accused.
No, madam. My condition is
co-accused. He is want to withdraw it. Let him go. The present petition is dismissed. Next person, the present petition is dismissed to as withdrawn with a liberty granted to the petitioner to surrender before the court below. You want some time on or before 5th of
within 4 weeks.
15th of May 2024, and move appropriate application under law, raising all his contentions. With this observation, the petition is to court surrender. That is a better idea. If you go, then you may be, get.
I know.
Item 2.
Yes.
That case where that lady was directed to be appeared on 4th. She appeared. We mentioned that case before Justice Swata, and
what happened?
That lady, they compromised that lady and the husband and wife. They were in love. They eloped. Thereafter, she went back to her father and again got married to another person. The case was registered by the informant, by the father is the informant. Now they don't want to proceed with the case. Both of them.
What are the offenses?
Offenses 376.
363. Charge sheet is filed. What is
boxer there?
Charge sheet is under?
Yes.
6 boxers there.
6 boxers. That's the problem.
On the death, she was measured. There are 2 date of birth certificates. One is Aadhaar card was 2000, and the voter ID, the school living certificate.
2 census, my lord. 2 to 2024, 21 to 24, my lord. Same thing, Passover and adjourn.
Miss Naidu is appearing. P. Naidu.
Patisha Naidu.
So the none appears for the petitioner. Even in the last date appearing, none appeared. In the interest of justice, adjourned. May last July.
Item 4.
Next week, my lord. Next week.
Adjourned.
Item 5.
May it please, my lord. My lord, this is a case for quashing of a complaint petition filed by the OP number 2. The allegations are made under section 294, 323, 427, and 506, my lord. My lord, in this case, my lord, apart from the oral testimony of the complainant herself, there is no other evidence in this case to support her allegations made against the petitioners, my lord.
Oral testimony is enough.
My lord, in fact, in the fact of
complaint, she has filed a complaint case and gave oral evidence. What else you need?
Again, my submission is that in this case, the injured is her husband, my lord. Even he has not given his statement under section 200 CRPC, my lord. Apart from her oral testimony, she has also not filed a petition under section 156(3) for further investigation of the case by police. Again,
what could be done? Correct. Cognizance order is correct.
Again, my lord, if we closely look into the contents of the complaint petition as well as the statement recorded under section 200 of
For
CR
closely looking the evidence, some other proceeding is there, not this proceeding.
my lord,
I am giving you opportunity to you argue all these things. That court will very closely look into it.
my lord, in this case,
Okay. I am giving you that liberty. Then counsel for the petitioner, in this petition, the petitioner is challenging the cognizance order dated 27/4/2022 by which the SDGM, the Court of SDGM both has taken cognizance of offences under section so and so in ICC case number ये पेज नहीं जाओगे 11 हाँ ICC court so and so. The learned counsel for the petitioner seeks to withdraw this petition to raise all his points at the appropriate stage before the court below. With this liberty, the petitioner is disposed.
Okay.
Yes, next.
Item 8.
My lord, this is a peculiar case, my lord. 990 ग्राम शुणिले बहुत डर लगे 990 ग्राम अफिम आज्ञा मो पाखु धरी ना मु खाली गोटे पेपर दौची जोटा कि बर्तमान आज्ञा हजूर पाखे नजर थी गोटे आईआईसी धरा पड़ा जलेश्वर लुचिक रहा 3 वर्ष पर से 10 लाख बदल चेंज हो
पेपर कटिंग
मैं मो खाली माने आणुची हजूर नजर को हजूर 990 ग्राम मो पाखु धरी ना कि ना सी कहते एलिगेशन हूँ पेज 11 एलिगेशन हूँ मुझे रास्ता कड़े ठिया होती मो पाखु आसिले शुंगिले टेस्ट कले जरी बांधिले कि मो दस्तखत नेलेनि कहले यही समय 20-25 लोक आसिक छड़े नहीं गले ना एलिगेशन कर गंडगोल कले आमको छड़े ने एफआईआर दे था एफआईआर भी देले 990 ग्राम मत चार्ज कर जोटा 990 ग्राम टा 2.5 हेल हूँ कमर्शियल 990 हूँ मिनिमम क्वालिटी मत चार्ज कर 18C रे प्लस हजूर 18C टा देखो NDPS Act.
But what is the stage now?
Stage charge sheet submitted, but I have not surrendered because मुझे surrender करी 10 वर्ष जेल मो बाहरी पारिबे नै मोर 18C रे मते जो चार्ज करछन दैट इज रॉन्ग हजूर टिके नजर रखन 18C टा
कॉग्निजेंस स्टेज आपन चाइल्ड आर्गू करिवे ना चार्ज स्टेज
नहीं मो कहि दोछ हजूर टिके देखि दियंत हजूर टिके पेज 32 पेज 19 18C हम पढ़ी दो 18 वन whoever in contravention of any provision of this act or any rule or order made or condition of license granted hereunder cultivate the opium poppy or produce manufacture possess sell purchases transport import interstate or export interstate use opium shall be punishable with the contravention where the contravention involves small quantity with rigorous imprisonment for a term which may extend to 1 year or with fine which may extend to 10,000. Where the contravention involves commercial quantity with rigorous imprisonment for a term which shall not be less than 10 years and which may extend to 20 years and shall also be liable to fine which shall not be less than 1 lakh rupees. Provided that court may for reasons to be recorded in the judgment impose a fine exceeding 2 lakhs also. 18C. In any other case with rigorous imprisonment which may extend to 10 years. अरे मो पाखुर तो 18A रे धरिले अफिम मो केस जदि धरिले मु जदि प्रकृत आउ अन्य किछि डिस्प्यूट करूनी मो यस मो पाखुर आपण धरले जदि आसीबो तो 18A रे आसीबो मोर अफिम मु धरली मते पनिशमेंट हो हटके एटा होछि गुटा हजूर भाई गुटा डिसीजन टे भी अछि ग्वालियर रे सेही पॉइंट रे ओनली कल्टीवेशन ऑफ पॉपी will come under 18C, not any other. My lord.
I try to appreciate one thing. At the cognizance stage, can I go into all these things? You can argue all these things at the charge stage.
Exactly.
whether this offense is made out or that offense is made out, you can argue that. It is at its very threshold. Investigation is still going on.
No, investigation completed.
Complete, okay.
That's it, submitted.
Then you are absconding.
Minor.
You are absconding. And the only apprehension you have is once you surrender, then you may not get the bail.
Minor, 100.
So that ground is not available in 482.
ମୁଁ ସେଥିପାଇଁ ଆଡ୍ନ ପ୍ରେୟାରଟା ଯୋଉ
Why
ବେଲ୍
don't
ମାଗୁଛନ୍ତି
you surrender and get tried and get bail?
my lord unless that 18C ଟା ଯଦି ଚେଞ୍ଜ ନ ହବ
I will record your argument here
my lord
and give you an opportunity to appear before court and seek remedy. I'll record your
only on my lord that is I am fairly submitting my lord but the, as regards 18C that must be decided first.
Decide not in this proceeding.
Not otherwise this will be rejected.
How can I decide in this proceeding?
My lord, that's a lower court.
And there discharge petition.
No, you sign the petition. That liberty I'm going to give you.
Cognizance may be taken.
I'll give you that liberty. You have definitely you have a case, but not at the cognizance stage. It is only at the charge stage you can very well argue this point, and perhaps you will be succeeding that.
No, my lord, that is true, but unless there is an observation of my lord to that
I'll observe it.
My lord. My lord, this is also decision of the Gwalior.
That also I observe.
Yes.
So that it will be helpful. Which paragraph, sir?
My lord.
What are the allegations against you?
My lord, carriage of him of 990 gram. That is small quantity, my lord.
Very word possession is there and his possession conscious.
No.
That has to record, my lord.
Mo pakur nahi na.
20 to 30% came there and assaulted the police person.
Mo na
taken away, my lord.
mo na FIR ଦେଲେନି କାହିଁକି ମୋର ତ କଥା ହଁ ଦେଲେନି ଆଜ୍ଞା ମୁଁ ଗଣ୍ଡଗୋଳ କଲି
Petitioner is seeking the quashing of the criminal prosecution initiated against him by the police under section 18C of NDPS Act. After investigation, charge sheet has already been filed. However, the petitioner has not surrendered to the jurisdiction of the court below. Land counsel of the petitioner submits that since even if the allegations and material available on record as material available on record is taken at its face value, the charges under section 18C will not be made out. At best, it could be an offense under section 18A. He relies upon the judgment of the Madhya Pradesh High Court, passed in such case, and paragraph shown for E paragraph 18. The petitioner in which 173(8) is open? No. Charge sheet has already been filed. The contention of the petitioner could be tested, could only be tested.
May say final PR has been
Final PR has been filed, and the contention of the petitioner could only be tested at the appropriate stage by the trial court. Therefore, this court is not inclined to interfere at this stage. However, liberty is granted to the petitioner to raise the aforementioned point before the court below by moving appropriate application. At this stage, petitioner seeks indulgence of this petitioner. The counsel for the petitioner submits of the counsel for the petitioner on instruction submits that his client would be appearing before the court below on or before 15th of May 2024 and move appropriate application before the court for a grant of bail as well as moving an application for discharging him from the charges from the case. case. Let the petitioner surrender before the court is on or before 15th of May 2024 and all remedy under law, under law. That's
My lord, the 2.5 is commercial quantity, but it is also less than that. That's what also.
He further submits that 990 gram of opium, what is?
Opium.
A gram of opium alleged to have been recovered, which is less than the commercial quantity. Okay. That point also you take. Okay.
Okay.
Yes.
Item 10.
This to the yes.
My lord, 457, 380 cognizance has been taken, my lord. My limited prayer before my lordship is that all other co-accused persons has been released on bail. And basing upon their statement, I have been implicated and charge sheet has been filed against me. Lordship, may kind enough to direct the petitioner to surrender and move for bail, taking into consideration the release of the co-accused
Challenging
persons.
the order dated 18/1/2023, passed by the Court of Courts.
NGN JMFC Rajnagar. NGN.
NGN come JMFC
Rajnagar.
Rajnagar in GR case number 414 of 2022. Then consequently the petitioner submits that except the statement of co-accused persons, no other material is available against him. So therefore the cognizance order is not sustainable. Cognizance order will not stand the scrutiny of law. How at this stage he seeks to withdraw this withdraw the present petition with the liberty to appear before the court below and move appropriate application for seeking discharge as well as for grant of bail.
But first hour, second hour, lordship. Magistrate will not.
On instruction, then consequently the petitioner submits that his client would be appearing before the court below, surrendering before the court below, on or before 15th of May, so and so, and move appropriate application before court below. If any such application is moved for grant of bail, the same shall be disposed upon the same.
Taking into consideration the co-accused persons. That lordship may say.
And he further submits that all the co-accused persons has already been granted bail. So in any case, he is entitled for on the ground of parity.
Item 11.
Yes.
Here, my lord, alleged offense under section 376 and I issue 376 My lord, in this case, my lord, the present petitioner informant belong to one family. Due to family dispute, my lord, the informant log this case. Informant is the grandfather of the present petitioner. Matter amicably settled, my lord, both parties.
Settled, my lord. I am appearing on behalf of the opposite party number 2, informant. And the
what? 376.
My lord.
Huh? Yes, Mr. Lograt, what to do?
That is actually not a.
What is the terms of settlement?
Due to the interference of the local gentries, my lord.
No, that's right, but you are the informant.
My lord.
What is the now terms? You have you settled? Are you staying together? What?
Let them, my lord, they appear before this your honorable court and file their affidavit, my lord. Today only I have appeared on behalf of the OP number 2, my lord.
376 2 and is there.
My lord.
You bring them, let us see.
My lord.
Write down, you file an affidavit.
My lord.
What are the terms of settlement? Why you have settled and everything. Any detailed affidavit.
My lord.
Giving a minute detail about the
Your lordship, fix a date, my lord.
Huh?
Your lordship,
I'm
fix a date.
fixing a date. They fix a date. Next week,
16,
16, 17.
25 May, April.
20.
25.
No problem. 20. Okay. Yes.
12.
Stay of proceeding, my lord.
No stay of proceeding.
May it please your lordship.
Lordship, in this case, the petitioner challenges the cognizance order dated 4/9/2023 in 1cc proceeding 13 of 2023 for the alleged commission of offense under section 138 of NI Act.
You are the accused.
I am the accused, Your Lordship. The factual matrix of this case involved, Your Lordship, the complainant is a proprietor of one Lalchand iron store in Bargarh district. And accordingly, an work order was culminated between both of them. There was some business relationship. The allegation of the complainant is that there was some outstanding of 66 lakhs of 38,000 sum of amount, and accordingly
You simply tell me whether you have issued the check or not.
the point of submission that I am making, Your Lordship, here the complainant has issued the check in the official capacity as the managing director. Here they have not incorporated or arraigned the company as an accused. I have relied upon two decisions of one of Honorable Supreme Court in Anita Hadda versus Godfather's Tours and Private Limited, where they said that it is imperative to arraign the complainant company as an accused. If you are vicariously liable, making liable.
For the petition submits that the complainant, the complaint under section 138 NI Act has been filed against the client without including the accused company. Therefore, the complaint itself is vitiated. Issue notice to the opposite party, returnable notice.
Stay, Your Lordship, to be connected. Your Lordship,
Check up how much? What is the check amount?
Kindly have a glance to
I know, don't show me the judgment. 63 lakhs.
Yes, Your Lordship. But thing is, another point is 202 CRPC has not been also complied, Your Lordship. If the accused is residing beyond the jurisdiction of...
You tell me one thing, statutory notice was issued to you. Have you replied?
Yes, Your Lordship. I have replied refuting.
Show me that. You have replied to the statutory notice. Otherwise, 139 presumption will operate again.
So therefore,
I will not issue stay.
I fairly submit. I mistakenly did not file. Have not filed that reply, but it is admitted in the complaint.
One thing, I issue notice.
Yes,
along with the reply and notice and all, you move another application. Okay? I will give a date. Only issue notice.
Issue notice.
Yes. You move, along with those reply and the 138 notice, statutory notice, you move an application for stay.
Statutory notice has been filed, Your Lordship. The reply has
reply and everything. You file and move an application.
This charge will be framed on.
I'm giving an opportunity to correct yourself. Incomplete petition.
I bow down to Your Lordship's consideration.
I would have acceded to your request because you are a young man. You have committed a mistake, so you correct it. Move application and come and mention. I'll entertain you. Okay. Now I'm issuing notice on that.
Charge will be framed.
No, nothing will happen. Move application tomorrow. Why have you committed mistake?
Sorry, I'll say.
Move the application. No problem. Anyway.
Oblige, Your Lordship.
Yes. Okay. Next day, 14. 14 Yes.
37.
No, 14 is also.
14, okay.
14 is waiting.
Great one.
Senior 3,000. Thereafter 37.
Complaint was filed against the petitioner Complaint was filed against the petitioner by Lady Mallards. Your Lordship will kindly turn to the complaint.
23.
Mallards?
Page 23.
Page 20.
294, 323,
Yes.
354, 354B, 506.
Mallards. Two cause of action. That the first cause of action arose on January 2022. Now, for some telephonic conversations, the complaint is filed after 1 year, 1.5 years, almost 2 years. This is in December 23. So, my lord, that would be that at that point. And the second, the direct cause of action arises on 15/9/2023 when the complainant around 11 AM was going for some urgent work and the accused blocked her way on the road and forced her to take him to her flat for fulfilling his sexual demands, and on the complaint's refusal, the accused grabbed her hand and tried to force her into his car. And in that process, your lordship may kindly remember the date, 15/8.
59.
15/9. 15/9. Now your lordship may turn to page 32. 32. Bhubaneswar to Bombay flight.
32.
Mala.
Yes.
Page 32. Bhubaneswar to Bombay flight. Lordship may see the date. 14th September 2023, 8:45. I land in Bombay on 14th September at 11:30. Then, my lords, next day.
Clear alibi.
My lords,
Clear alibi.
I am not in the country. On 15th, I am not in the country. Next page. My lords, page 33. I was in Zurich. Your lordship will see Mumbai to, my lords, Zurich. Lufthansa. Flight takes off at 2:30 and arrive. Lordship will find that at in the left hand side column.
Then, okay, you got rid of the second cause of action.
My lord.
First one?
First one is not maintainable, my lords. First one is not maintainable on a public place. I have the
468.
My lord.
Are you relying upon 468?
No. The complaint.
January 2022.
Yes.
How will you get out of it?
My lord. Video call.
No, that the first cause of action arose on January 2022 when the accused started calling.
Yes.
The complainant from his number so and so and passed
So,
sexual
odd hours.
and also made video calls.
My lord.
After starting
Video call,
to
January 22.
husband.
January 22, and the FIR is launched in December 23.
There is no legal bar.
No legal bar.
468.
No legal bar. Yes, my lords. No legal bar. Now your lordship may come to the my lord's background, the real background of the case. This directly fits in with that age-old, my lords, the classic judgment of Bhajan Lal actuated by malafide. This is a direct, my lords. Your lordship will see.
What is she? She is working under you.
No, she is the wife of my employee, my lords, who was terminated by me for stealing money, for stealing from my safe. There's a video recording.
Why don't you settle it?
I lodged an FIR.
Can you settle it?
My lord, they are forcibly occupying my flat, not leaving, and there, my lords, the husband has colluded and sold off 2 of my lands, my lords. I'm a builder. 2 of my lands worth 2 crores. And also, my lords, he has colluded with my partners, and now I am facing an award of 2 crores. Arbitration award. He conceded.
Now,
without my
the problem
knowledge.
is the plea of alibi at the cognizant stage.
My lord, there is a direct judgment, my lord. I can understand your lordships.
Can the court go into the plea?
My lord,
It has to be established.
There is one
Trial. That's the
judgment.
difficulty. You have a clear case of plea alibi.
My lord.
Because you have filed the boarding
Ticket. My lord. So my only
It's a
problem
clear
is,
case. But in the cognizant stage, can I go into this?
your lordship can is my only submission. Your lordship can, if your lordship looks at this Thapar, Rajiv Thapar's case, your lordship must have seen that case.
Yes, that is
Rajiv
not
Thapar.
the cognizant stage.
No, that was 2013 voluntary Supreme Court SCC page 330.
Which stage is that? Which paragraph you want?
Paragraph. Paragraph 30. Paragraph 30. Based on the factors canvassed 30.
Based on fact.
Based on the factors canvassed in the foregoing paragraphs, we would delineate the following steps to determine the veracity of a prayer for quashment raised by the accused by invoking the power vested in the High Court under Section 482 of the Supreme Court, or the CRPC. Step 1. Whether the material relied upon by the accused is sound, unreasonable, and indubitable, that is, the material is of sterling and impeccable quality. 2. Whether the material relied upon by the accused would rule out the assertions contained in the charges leveled against the accused, that is, material is sufficient to reject and overrule the factual assertions contained in the complaint.
Let me issue notice.
Secondly, my lord, I have given a chart for your lordship's appreciation. Where is the chart? What is the chart? Kindly, my lord. Even my lordship's first query, which is troubling your lordship, my lord, that is also not made out. Your lordship will see, telephone call does not attract. The first one, 294. Whoever to the annoyance of others.
Again, that's the whole difficulty. You say that the charges are not made out against you.
No, not
on
even
the basis
only.
of the allegation. Then
No, not in
the test is somewhere else, not in the cognizance.
No, lordship may kindly look at the ingredients of the mallet offense. Does any obscene act in any public place or stings, recites or utters any obscene song, ballad or words in or near any public place?
Right.
This
Okay.
is-
Okay. Let us see.
This is my point,
See,
Mallet.
I think
So
if you notice, then let us try and.
Mallet, I have a suggestion. Let the investigation or whatever it goes on, I may be protected. I cooperate with the investigation. Lordship may protect me. And my evidence, I'll furnish that this evidence before the police. Let him examine. I don't want harassment at this stage, my lord. Every day the police will call. I can't run my business.
Don't you think that you have come to a wrong court?
My lords,
Wrong court in the wrong.
I would think, my lord, I've come to the right court in the right forum because of, my lord, that classic Bhajan Lal proceedings actuated by malafide. That is still, my lord's good law as upheld by my lord's Honorable Justice Nagar.
It is a 156.3.
Yes, you can't make that prayer. Even that prayer cannot be made.
No. Now police is directed to investigate.
My lords. So therefore, let the investigation or whatever continue. I may be
You submit
protected.
all these papers, sir.
No coercive action. In the meantime, I may be permitted, given some protection, I'll furnish all these papers to the
Why
police.
don't you go? You get see what in this case. Who will stop you getting bail?
My lord's question is 354B. That is the whole difficulty.
No, it's a clear case of
It is a
alibi.
clear case, my lord.
I will record it and I give you opportunity to go and do. I'll protect you for some time. Go and.
My lord, your lordship may, I will be in difficulty. Your lordship knows from your lordship's experience how the trial courts they operate, my lord. They will not touch it. Moment there is a 354 or a 354B, my lord, they will not touch it. And I stand the risk of.
See, there are two cause of action.
My lord.
354B
My lord.
could have been attracted if the second cause of action is sustainable.
My lord.
In so far as the first cause of action is concerned, 354B will not be attracted.
My lord.
Okay, I will record all these things.
My lord.
In so far as the second cause of action is concerned, there is a clear cut case of alibi. You are not there in the country.
My lord.
So 354B can't. How they will get 354B?
They can't, my lord.
So then how are you apprehending?
So that is my answer. My lord. 482, Priyanka Srivastava's case, your lordship knows, automatically 153, 156.3 can't be, my lords, directed by the magistrate. Magistrate has to apply mind at that stage. There has to be an application of mind.
That's right. That's the general principle. The first principle is that.
My lords, first principle is that, and also, my lords, Bhajan Land's case, my lords. Actually, this is a proceeding clearly actuated by malafide. Lordship may kindly see my termination letters.
See, the problem is then what I can do is I can examine. If you want to rely upon all these things, I have to examine it. I have to issue notice. I am simply issue notice. What to do? I can't see investigation is going on. I can't stop it.
That is the reason.
I can't stop it. I can't give 438 relief also.
No,
so therefore, what I am saying is,
that is
I will allow you to. I'll record your all submission. I will relegate you to the police. You submit all the documents. Let the police examine any case is made out or not. And meanwhile, I'll protect you for some time. You go and avail remedy under law. So everything is balanced. I'll record your statement. This very vital statement. Right now, the petitioner, the opposite party number 2, has filed a complaint. 1CC case number 5650 of 2023. Inter alia alleging as under 24 page 24, cause of action. Cause of action. It appears that the complaint case is based on primarily based on 2 incidents. The first incident pertains to January 2022, whereby it is alleged that the petitioner has made certain phone calls and made some sexual comments against the opposite party number 2. Insofar as the second allegation is concerned, it pertains to an incident on 15/9/2020. Learned counsel for the petitioner has relied upon the boarding passes to substantiate
Visa.
and visa
Visa
documents and boarding pass to substantiate the fact that on the day when the allegation was made against the petitioner, he was not even in the country, in the country. Therefore, the second allegation made by the opposite party number 2 is definitely a concocted story. On the basis of the aforementioned contention, the learned counsel of the petitioner seeks indulgence of this court. I'm afraid at this stage the court should interfere in the present matter because the investigation is still on. Therefore, the appropriate course would be that the petitioner shall submit all the documents before the investigating agency, and the investigating agency should consider those documents. Petitioner also seeks liberty to appear before the court below.
To take appropriate. I can also appear here.
Petitioner also seeks liberty to avail further remedies for protection.
Appropriate proceedings. Appropriate proceedings.
For protection by resorting to appropriate proceeding under law. The petitioner may avail all procedural remedy available to him under law on or before 15th of May 2024. Till then, no course of action.
And Rashmi, kindly
I could protect it till 15th and go. That's a balancing thing, you know.
No, that observation regarding the second second incident, that would gives a small observation.
I gave that it is a concocted story according to you. That I record your statement because you were not there in India. That also I said. I think that is sufficient.
Grateful. Urgent copy of your lordship.
Yes. Any senior?
37.
No. Senior.
37. 37, my lords.
Yes, sir. 37 I'll take and then I'll give. 37. 37 for it to go. Yes.
Yesterday, my lordship was pleased to.
Can your lordship add only direction to the InfoCity PS? Police InfoCity PS.
Police InfoCity. Yes.
My lordship was pleased to direct me to appear the petitioners physically, and as because they are out of state, they are appearing pro vici, my lord.
For Quashing.
My lord. My lord has already observed in so far that CRLMC 312023. My lordship was pleased to pass, but
there are two cases, na?
No, my lord. One case has already been disposed of. That is CRLMC 3102 of 2023. It has already been disposed of. But my lordship observed therein that though
in this case, my lord,
yes,
challenging the criminal proceeding, my lord, under section 366, 366A, 34 of Indian Penal Code, my lord. Allegation is that the victim was missing, and during search, Pravina alias Tukuna took away her to Bilaspur the victim had taken rupees 1,50,000 and gold ornaments from her, my lord. Or her father lodged the FIR, my lord. Subsequently, my lord, the matter has been compromised and one of the co-accused persons also acquitted, and the PW1, the father stated that after 3 days of missing of my daughter, she was rescued. On my inquiry, she disclosed that out of anger, she had left the house and while moving in the train, she was rescued by the neighbor Praveen Das. And while they were coming in the station, police apprehended them. By that time, incident, my daughter was 17 years. And next page, my lord, she has stated it is a fact that on suspicion I lodged the FIR, and further cross-examination is stated my daughter is now married and she is staying at abode at Singapore. It is now difficult for her to come, page 24, my lord. Certified copy I filed. It is difficult her to come and depose. It is a fact that my daughter had not made any allegation against the accused. In the interest of my matrimonial life of my daughter, I don't want to proceed with this case, my lord. And he is appearing in this case, father, my lord.
I am appearing by the informant and opposite party number 2, and also I have given affidavit.
On merit, you want quashing or settlement?
Quashing of proceeding, my lord.
On merit or settlement?
Compromise is there.
Matter has been settlement, my lord. Settled. It also appeared. Informant also appeared in this.
Dilip Kumar Sahu.
Baleswar.
Oh, yes, my lord.
Yes. What do you see?
Go on.
Sir, close to the
The victim has married somewhere else.
Out of anger, he
No. Victim married and settled there in
married at residing at Singapore, my lord.
And
marriage to another one.
Married to another one. In the certified copy, I have filed.
who was the co-accused? Who was acquitted?
Co-accused, my lord, acquitted. I have annexed annexure 4, my lord.
Who is he? Whatever.
Co-accused, my lord.
Shubha Prakash.
Subha
Prakash Saha.
Tinku alias Subha Prakash Saha. In the judgment also it has been mentioned in this evidence of Schedule 1 deposed that on 3/4/2023 his daughter was missing from house. Thereafter he reported the matter to the police. After 3 days his daughter was rescued. On enquiry he disclosed that out of anger she had left the house and while she was moving in the train she was rescued by the neighbor Praveen Das. In his cross-examination, he admitted that only on suspicion he had lodged the FIR against the accused persons. Due to family quarrel, the victim had left the house. The victim has already married and she was staying abroad.
Right on. At the instance of incorporation, at the instance of opposite party number, where is that? At the instance of opposite party number 2, FIR number so and so under section so and so came to be registered against the petitioner. After investigation, charge sheet was
petitioner is also present.
After investigation, charge sheet was filed, and he was absconding.
Yes, ma'am. Yes,
charge sheet was filed. The petitioner was never apprehended by the police. However, one of the co-accused person, namely, what is his name?
Co-accused, my lord, Tinku alias Subha Prakash Saha.
One co-accused, Tinku Prakash, Tinku
alias
Pinku,
Pinku.
Subha Prakash Saha was apprehended by the police, and he was put to trial. The ad hoc additional sessions judge Baleshwar, by the order dated 2nd May 2012, in Sessions trial case number 75/171 of 2010, has recorded an acquittal in favor of the co-accused. While recording, while taking into consideration the statement of PW1, that is the informant and opposite party number 2 in the present case, the co-accused person was acquitted. Relevant is to reproduce the para 6 of the said judgment. Page 28, para 6. Para 6. Next paragraph. Insofar as the present petitioner is concerned, the petitioner was had been absconded.
That's good.
And however, at this stage, the petitioner has entered into the opposite party number 2 has entered into settlement with the petitioner. The opposite party number 2 is the father of the victim girl. Victim girl is present in the court through VC, and is being represented by his counsel, who identifies him. He filed an affidavit dated other dated 8/4/2024, inter alia, stating that her daughter has already married and settled abroad, and she is not in a position to she would not come to India to depose before the court. He also stated that in order to save the marital life of her daughter, he has entered into a settlement with the petitioner. The petitioner is present before the court in person, and he being identified by the learned counsels. He has filed the self-attested photocopy of the self-attested Aadhaar card to establish his identity, which is taken on record. The petitioner has also filed an affidavit dated so inter alia, stating that he has settled the dispute with the informant, that is opposite party number 2, opposite party. Both the affidavits are taken on record. Mr.
Father has also filed Father has also filed
Mr. Rahul, appearing for the state, submits that taking into consideration the peculiar facts of the present case, and the fact that the informant has already deposed before the court in the while the co-accused person was subjected to trial, that due to misunderstanding he had filed a complaint. This court can give indulgence to the petitioner. Taking into consideration the statement at bar and particular facts of the present case, so is question.
Item 51 will not compromise matter, both the parties are present.
51 compromise. Right. All that.
May I please your lordship? Case under section 498A and other allied offences, my lord.
Oh, where are the parties? All them.
Both the parties are present.
OP2.
OP2 actually.
Adjourned. Yes.
16.
May I please your lordship?
Yes.
The petitioner is the informant, my lord. In this case, my lord, 18 witnesses already completed, my lord. My 18 witnesses, 16 witnesses already completed, only 2 witnesses. The 2 witnesses, one witness is police witnesses, another is search and seizure witnesses, my lord. In this way, we had read 6 months already date to date no change. So it may be targeted, my lord.
Where is the proceeding?
Last,
my lord, annexer is the series, my lord, you may kindly see. That is 16, annexer 3 series, that is.
yes, my lord. Out of 19, 15 PW has already been
examined.
Yes.
Only 4 remain.
Yes.
No, only 3.
Now, out of totally 19 charged witnesses, the vital witnesses, including
Already
15, has already been
examined.
So, shall I target it?
Target.
I don't know how many 4 witnesses you will examine, all 4 or what?
No, rest for
He
4.
says 2 witnesses remain.
No. 19
No.
has been examined. What you have annexed?
Only 2
annexed.
witnesses remain, my lord. Remaining. That is only witness 3.
And why do you apprehend? The 2 witnesses will be examined.
Yes.
My lord, they
See,
agree in the case, my lord.
This case is of 2022.
My lord, we have
The
sorry.
See, your apprehensions are,
I am the informant,
2022
my lord.
case.
I am lady. We should go to the out of woman state.
That's
because I
right, but
inform-
see, it's 354 and all these things. And 2022, November 2022 FIR.
Yes, my
Now the trial is going to be concluded.
Yes, my
Within 1 year, basically.
my lord.
November 22, leave 22, only through.
I'm obliged. You
FIR is 2022, November 2022. Investigation, when the charge sheet was filed?
Today's target, my lord.
Charge sheet was filed.
Charge sheet, my lord, you may kindly see Annex 2 page.
When the charge sheet was filed?
Charge sheet my lord 30/12/2022
See, December
22
is over. Within 1 year, the trial is
Going to-
virtually concluded. Why are you apprehending unnecessarily? Why are you apprehending?
Expedience.
Right of the FIR in the present case was registered on 23/11/2022. After investigation, charge sheet was filed on 30th/12/2022. The trial of the case is proceeding in a satisfactory pace. Out of 19 witnesses, 15 witnesses have already been examined. The present petitioner, being the informant, seeks indulgence of the court for a direction to expedite the trial. Since only 2 witnesses are left to be examined by the prosecution, and the trial is proceeding in a satisfactory pace, this court is not inclined to interfere in this matter. However, not interfere in the matter, and as not interfering in the matter. However, it is expected that the trial court shall do well to see that the trial is concluded as expeditiously as possible. Yes. Next. I will not target like this. Yes. 18. Yes. Pass over.
No, the offense under section 303/307 is a case of 2020, madam. 341, 307, 323, 324, 379 and 34 of IPC. Allegation is that informant while going to take sarbat in near the Jagannath temple, 3 persons came and assaulted him by means of a deadly weapon with an intention to kill him. Out of 3, my lord, petitioner is one amongst them. He has come up challenging this order on the ground that they have entered in. There is no injury, in fact, my lord. No case is made out. There is very big chance of conviction. My lord. And both of them are present before the last. On the ground of compromise, they don't
What
want
about
to-
the other accused person?
Other 2 accused persons, they are on bail. They are on bail. He also doesn't want to continue with this case.
But you can't be selectively settle the dispute with one. There are 3 accused. Either you have settled the dispute cause all or no.
You also all 3 was there to come.
You implicate them as a co-petitioner. Let us see. I can't quash the FIR as against one accused.
That is
Merely
also,
because you
that is
settled with
also
one.
possible. Not that it is.
charge
If
sheet
he
has
wants
been
to, suppose somebody is falsely implicated. He doesn't want to implicate him.
Then on merit you argue.
No.
No question of settlement. If you it's a matter of settlement, then you have to settle with all accused. You can't be selective. That I will
Allow me to
settle
amend.
because you
Allow
have
me to
taken some
impli-
money.
Yes, but I understand it.
That's better.
Only thing, my lord, NBW is there against me.
NBW
Till
is
then, it is going, ultimately it is abuse of process, of course. If ultimately the matter will go on the ground of compromise, my lord.
NBW,
Yes.
where is that order? NBW?
Annexed, my lord. At page,
running page
Petitioner is one of the accused out of 3
70.
in the FIR number so and so.
So,
The land council
70.
petitioner submits that he has entered with entered into a settlement with the informant oblique victim. Informant victim same?
yes, ma'am.
Same or different?
Same person.
Informant oblique victim of the present case who has been implicated as opposite party number 2. Opposite party number 2. Mr. Mishra further submits that he would be impleading other 2 accused person as co-petitioners in the present case. let him implead the other two, the liberty granted to the petitioner to implead the other accused persons as co-petitioner in the present case, within 2 weeks, within 2 weeks. Within 2 weeks, the Mr. Mishra further submits that on
On by C bar code, page 17.
On by C.
22 December
on
20.
22/12/2020, NBW against the petitioner has been issued by the SDJM Puri. SDJM Puri. Taking into consideration the fact that the petitioner and the opposite party who have settled the dispute and seeking quashing on the ground of settlement, the same is under consideration by this court. The operation of NBW issued by the SDJM Puri, by its order dated 22/12/2022, shall be kept in abeyance till next date of hearing. Yes.
You'll also fix it.
You will give it.
Okay.
Yes.
Item 20.
Yes.
Yes, my lord. You'll also that come to annexure 1, page 8, my lord.
Page 8.
Yes. At the instance of one Sukanti Pradhan, FIR lodged against the petitioner under section 420, 468 and 506 IPC. That apprehending arrest, I have approached this noble court. You'll also see at annexure 2 at page 16. And I was given para 5. It is directed that the petitioner shall be not arrested in connection with so-and-so case. Subsequently, I was granted bail. In the meantime, annexure 3, page 18. Dated 26/4/2024. Charge sheet has been filed, charge has been framed, and the case is posted. The accused person is in police bail. Now here, the offences are 468, 506, 465 IPC. Here, so far, offence under 468 is concerned, the punishment prescribed it more than 7 years. Since I was thrown out on bail, you'll also die that I'm ready to face the trial. The petitioner maybe to continue on previous bail. That is what my limited grievance is.
No. You were on bail, huh?
Yes, I was on bail.
And now 468 is added in the charge sheet.
Yes.
Charge sheet is.
Yes. No, charge.
The petitioner was on police bail, my lord, as according to the interim order of
from the very
granted by the
inception.
High Court.
No. From the very inception, 468.
Thereafter, charge sheet has been filed.
Annex 1, page 8. 420, 468, 506 was there from the very inception.
Then what is the problem then?
No.
You have been on the bail. You have
Yes.
you continue to bail.
Because
What is your appeal?
the matter is based, JFC G Uday agreed, it's pending, my lord. And notice has been issued for appearance.
Go and appear, you are on bail.
No. The lordship kindly observe that. That is
You are already on bail.
I was on police bail, my lord, not on court bail.
Whatever, that will continue. No? Right now. The FIR was FIR number so and so under section 468 only 506 only 465 IPC came to be registered against the petitioner at the instance of came to be registered against the petitioner. He was given notice under section 41, 41C. 41C, yeah, 41 CCR.
No, not 41C. Personal direction of this honorable court, I appeared on police bail.
He approached, he filed ABPL
9702 of 2021. Of 2021.
Seeking the concession of pre-arrest bail. The coordinate bench of this court by order dated 10/8/2021 granted the petitioner the concession of anticipatory bail. The after investigation, charge sheet was filed and the cognizance
was
taken by the JMFC.
G Uday
Udayagiri by order dated 26/4/2022 under same section 468, 506 and 465 IPC. The petitioner is assailing the said order. I'm not inclined to interfere with the matter at this stage. However, the petitioner is given liberty to raise all his points at the appropriate stage.
No. May I pray one thing?
Yes.
Yes, yes,
Right.
yes.
The petition, counsel for the petitioner appealed that despite the fact that the this coordinate bench of this court has granted the concession of anticipatory bail, to the pre-arrest, concession of pre-arrest bail to the petitioner, in view of the fact that offense under 468 CRPC cognizance has been taken under the for the offense under 468 CRPC. The concession of bail may not be extended once he appears before the court. This appearance is not appearance is unfounded in view of the fact that this court has already granted anticipatory bail to the petitioner for all the offences. Please proceed. Yes.
Yes, sir.
Next.
Please, Your Worship.
This is a case under section 420-34 of IPC. Coming out of a misconception between the transporter and the person who is receiving the consignment. The consignment was being transferred from Britannia to Flipkart. The petitioners are the managers of Flipkart. So what happened is the transporter, while taking the POD, it was mentioned instead of 277 boxes which were returned, instead of 277, it was wrongly mentioned 621. So apprehending any kind of blacklisting from Britannia, this transporter filed an FIR before the Chandaga PS that such and such mischief might have been committed in the records. That instead of 277, they have mentioned 621 due to some. But that was a clerical error. Subsequently, that has been cleared between Britannia and Flipkart. There is no money involved. And both the transporter and the informant is the transporter and the manager.
And also he has attached a withdrawn application.
Yes, madam.
Is present?
Kindly see Annexure 2, where he has already withdrawn the FIR, but the police is not accepting.
Under section 420 and 34.
Only 4.
Right on. At the
He's appearing for the informant.
Right.
He's filing affidavit.
Right, the instance of opposite party number 2, FIR. There are 2 petitioners.
There are 2.
The FIR number shown
There
cases registered against the petitioners. The letter counsel for the petitioners submits that. Counsel for the petitioner submits that due to misunderstanding, the FIR was registered by the opposite party number 2. Opposite party number 2. Subsequently, he has subsequently he has also given a letter to the concerned police station seeking withdrawal of the FIR. Withdrawal of FIR. Mr. Rahul, appearing for the state, submits that indeed the informant, opposite party number 2.
On this
29th of February 2024.
is 2902.
By letter dated
2902 by 2024.
29/02/2024 had given a letter seeking withdrawal of the FIR. Withdrawal of the FIR.
The Vishwabhushan Jagat Prasad apana.
Next, the parties have now settled the dispute. Both the petitioners and the opposite party number 2 are present in the court, being represented by their respective counsel and identified by them. They filed their self-attested copies of the Aadhaar card to establish their identity, which are taken on record. The opposite party number 2, the informant, has also filed an affidavit inter alia stating agent Paratri, which is taken on record. Mr. Rahul, appearing for the state, submits that the the FIR was lost on 24/2/2024, and immediately thereafter, under section 420 and 34 IPC, before the investigation was taken up by the IO, a letter has been received from the informant that
Vishwabhushan Jagat Prasad Jana.
informant that he doesn't want to proceed with the case, and the case was filed because of the misunderstanding. Therefore, the FIR, though under investigation, could be quashed. Next paragraph. Taking into consideration the fact that the parties have settled that they should file an affidavit before this court, and they are present in the court in person, reiterating their stand that they don't want to proceed with the matter, and the fact that the informant has given a letter seeking withdrawal of the FIR, there is no legal impediment in quashing the FIR. Therefore, FIR number so and so qualifications are quashed. Yeah. 22. Yes.
May I please, your lordship. Here, my lord, I filed this application for quashing the GR case pending against the petitioner, my lord. The fact of case is that one FIR is lost against the petitioner and on other Sandeep Biswal, my lord. In between, the matter was already settled between the parties, my lord. But in the meantime, the said GR case was split up. The said GR case was split up, my lord. So the offense against the Sandeep Biswal was committed to the additional sessions judge Kendrapada, my lord, and trial was started, my lord. In trial, my lord, the matter was compromised and the said accused person was acquitted, my lord. Thereafter,
you were absconding.
my lord, I am the absconding, my lord.
He is absconding, and in spite of granting the order from this Hon'Ble court for first hour and second hour, he didn't take. Perhaps he
The
did
trial
appear.
My lord,
the informant will settle with you. You will be acquitted. What to do?
My lord, my humble submission before lordship, I have submitted the deposition copy, my lord. With lordship's the permission, my lord, I place this the deposition copy, my lord.
Deposition will not help you because those evidences are qua that accused.
No, my lord, if
What will I do? You bring him, the complainant settle here.
Complainant.
Bring him. Bring the complainant, informant. If he supports here, then I can take a view.
Yes.
I can take a view in the light of his statement already given in the court. Who are the other accused? Bring him. Next week with the king for
My lord,
bring him, get an affidavit
my
from
lord,
him,
my lord.
and we'll call. Okay?
My lord.
Okay, next.
20.
Next.
Obliged.
Item.
24. 23.
Please, lords. 23 urgent. What is this 23? That's the problem. Bail matter.
CRLMC 847/2024.
No, CRLMC 1083. Okay. Yes.
23 was by P.K. Rai.
Senior counsel.
Senior counsel was.
He is in some other matter. Okay. Yes. You be carefully see what is the number between. Yes.
24. May I please, your lordship? The Belgium matter. Belgium
You
matter.
tell me when you were on bail.
Lordship.
When you got the bail.
138 NI Act. Previously, he was
on bail. NPW was issued on?
Issued on 13/10/2023.
23 appear on or before 15 May. 500.
You have the man of Andhra, so can some other someday.
15th, you are accused 15th May.
That's okay.
Yes.
25.
May I plead? Belgium matter, my lord. Bail is granted 23/4/2005.
23/4/2005.
5.
And,
NBW 6723.
67
23.
23 500.
Obligation.
Yes.
My item 26 Miller,
Hmm.
Belgiometer Miller.
Hmm.
NBW order dated 7/10/2023, running page 10. Petition was on bail earlier.
Date. Give me the date when you got the
Date knowledge
was on
nahi.
bail. Was on bail.
Bail jayech.
7/10/23 500.
Yes.
May I please, Your Lordship? My lord, this is a Belgium matter. My lord, the present petitioner was in bail from 16/1/2018 and
16/1/2018.
and
NPW
issued on
25/4/2023.
Yes, Your Lordship.
500.
Obliged, Your
How
Lordship.
many of you are there?
Only one present petitioner. Obliged, Your Lordship.
Take bail on 23/7/2021 and NBW issued in the month of February this year, 23/2/2024.
500 each.
My lord.
500 each. Yes.
29. Please, my lord.
Yes.
My lord, here, my lord, once the case has already been dropped, that has been disposed of since long. Since, my lord, by the order dated 21/4/2005, there was a mutual decree has been passed between husband and wife.
What
Since
decree in a criminal case? What kind of?
that is Annexure 1. How the NBW again in the same matter has been issued?
What is this decree? What
That is, please see, Annexure 2, sir. Page, sir,
These are civil proceedings.
civil proceeding, that is before the family court, just family court, Kotak.
Maintenance.
During that period, both the husband and wife outside the court decided the matter that they should stop the proceeding and the divorce position accordingly allowed.
Mutual consent decree.
There, sir, last order. Hence, the petition under section 13 B of the Hindu Marriage Act is allowed. The marriage solemnized between the petitioners dated 4/2/1982 is hereby dissolved by the decree of mutual divorce. The CP number 4117 of 2001 pending before the court be dropped. That has been dropped. Nothing is there. How can the NBW by the Annexure 1 has been issued? I fail to understand. And when I going to appear and file in Vokalarnama, that I have been prohibited not to file the Vokalarnama. How ठीक है हाँ कोर्ट रहे ना
There must be something. You go and tell the court.
Sir.
Go and tell the court.
No. This is the position. He is also an advocate. The present petitioner is also a practicing advocate. He has also dissolved the problem since long. And why and how?
One minute. When was the NBW issued?
NBW sir issued on 23.
Huh?
2/5/2023.
No. 9/9/21.
এটা কবে ইস্যু হয়েছে? Yes, 9/9/21. But the proceeding has been dropped since 2025. 2005, the proceeding has already been dropped. By the
That was a mutual divorce petition.
That has been accepted.
I don't know what is the order passed in what you call the maintenance.
Because
there may be some maintenance order.
Nothing is there, sir. Nothing is there. Nothing.
How will I know from this proceeding, sir?
But this is the order, sir. I have annexed that order by the annexure.
You have only said that insofar as the mutual divorce proceeding is concerned, that is dropped. That is a decree is allowed. And
allowed. Yes.
But is there any order for maintenance?
No.
Which is due?
No, nothing. Nothing is due.
How?
Since
you make a you show me. Suppose there are some maintenance order.
Yes.
Which has not been executed.
Yes.
Now she might have filed an execution petition. How do I know?
Sir, once the proceeding has been dropped, once a proceeding, is there anything left to be decided? Once the final proceeding,
where is that dropping? Which proceeding is dropped?
21/4/2005, sir.
Show me the page.
That last page, sir. Yes, page 19.
See, if you shout so much, then I will be confused.
No, sir.
If you fully,
Sir. Last para, sir.
Which page?
Page, sir. Internal page 19. That is 25.
25.
Sir.
Okay. Come to 25 page.
Yes. Hence the petition. Last para, sir. Last para.
1 minute.
Sir.
1 minute. This is the petition.
Yes. Order.
This is the petition. Prayer 21 is prayer, 22 is affidavit, 23 is affidavit,
25, sir.
24 is the order. Okay.
25, sir. 25, last order, last para.
This is the civil proceeding.
Yes. Yes.
Civil proceeding number 256 of 2005.
5, sir.
Okay.
Yes.
This is dropped.
Yes.
This is dropped.
Yes, yes.
And in a civil proceeding, NBW is not issued to you?
No.
Come to now the
Yes.
NBW order.
Sir.
NBW order.
Sir.
This is just note it down. 256 of 20.
257 2005, sir.
It is dropped.
Dropped.
Okay. Now come to NBW order.
Yes. Notice that despite the issuance of NBW and DW, again the opposite party Vishwanath Mahapatra, son of so-and-so.
Read at the top. Subject. Execution of NBW and DW.
Sir,
in CRL.
MP number 518, 16 and
drop.
Yes, that has been dropped, sir.
Proceeding drop. Wasting your time.
अरे बुझी पार that has been transferred, sir.
Sorry, nobody cares.
Sir.
How will you relate that civil proceeding with this? You tell me.
Because there was a transfer. The civil proceeding.
Where will I get transfer and everything? Whatever you will say, I'll have to accept it. You show me how is the transfer, when it transfer, in a environment also.
Sir,
bail drop, bail jump matter. Why are you?
No, this is not Belgium, sir. This is not Belgium. Please direct the I to appear before the concerning court. With all these documents, he can pass the region order.
That's what I'm saying.
Yes, we can pass that order. Once the proceeding has been done, what remains to be decided? Why there is an NBW? Because, sir, once there is a transfer, then there is a new number. Once transfer from one.
Where have you said those things? You tell me. Where have you said those things?
লেখা আছে এটা কোন লেখা নেই এই বার করছে এই জোরে ট্রান্সফার হলা বসে নোয়া নাম্বারটা
relate that criminal.
Yes, sir. Yes, that is the new number. Yes. Page 3, sir. There.
Where have you?
हाँ सीधा लिखी page 3 रे. Page 3, sir. Page 3.
धीरे आराम से कौन तो.
Sir. Page 3.
One can understand.
Yes.
आपण तो गुड एमिति बनाउछन्.
Sir, the case was transferred. Sir, the case was transferred to the Lord and Family Judge Noyagarh.
1 minute. Where you are reading?
सुनो तो ठीक है सुनो तो कथाटा. Page 3, sir. Page 3 of my petition.
A reminder sent to local police on
Yes.
Saturday, CRLMP number so of CMC and execution proceeding 125. It is an execution proceeding.
Sir?
Execution proceeding 125.
Yes, execution arises out of the same proceeding. Yes.
Right. Petitioner is seeking quashing of order dated 9/9/2021. By which the family court Nagar
yes
Nagar has issued NBW against the petitioner in CRLMP number 518 of 16
of 17
of 17
of 99.
1990. Then consequently, the petitioner submits that the proceeding pertaining to the said
Attend finality.
aforementioned case has already been dropped because the parties had already settled and sought for mutual divorce, which was already allowed.
Yes.
So therefore, there was no occasion
Yes.
for the court below to issue NBW.
Yes.
NBW. Since there is no clarity in the matter whether this NBW has been issued in the case which has already been dropped or not, I am of the pension view that the operation of the NBW issued against the petitioner on
sir
9/9/2021 kept in events and the petitioner is directed to appear before the court below on or before 15th of May 2024 and apprise this aspect of the matter to the court below and pray for dropping of the entire proceeding.
Yes.
Dropping of the entire proceeding in view of the order dated.
Sir, 21/4/2005.
21/4/2005. 25.
in civil proceeding number 256 of 2005.
With the aforementioned observation, the NBW issued on 9/9/2021 directed to kept in events till 15 May 2025.
24.
24. ठीक, चलो.
Obliged, sir.
Belgium matter.
Yes.
Belgium. Bail was allowed on 8/3/2010 and NBW was 12/12/2022.
How many of you are there?
And
Oh, 5.
it's 5%.
500 each.
Obliged.
500 each. 500 each.
31.
Back pattern, my lord. My lord, one pass over matter, my lord. 18 pass over 18, my lord. If you lordship permit me.
Sorry?
Pass over matter 18, my lord.
That will be taken up after lunch only. Yes. We are in which item?
Item 31.
21. 31, yes.
31.
500 each. NBW. Yes, next.
Item 31, my lord. Here the petitioner was on police bail, my lord, since 25/4/2016. And the NBW has been issued on 22/12/2023, my lord.
500. Police bail in the one. Yes.
32.
Obliged.
Matter related to Belgium matter. My lord, petitioner was on bail by an order dated 28/7/2017, but 8/12/2023 due to non-appearance and NBW issue.
500. Yes.
33.
33, my lord, Belgium matter. 5 petitioners are there, my lord. 2 NBW order are there. Page number 12, my lord.
So all of them were on bail.
Yes, my lord.
All of them were bail. 5 petitioner. NBW was issued on 24/4/2023 and thereafter on 25/2023.
For my lord, petitioner number 2 to petitioner number 5. The NBW order was issued on 24th of May 2023.
Sorry, NBW was issued Quadi petitioner number 1.
Petitioner 1 on 24th of April 2023.
Tell me which petitioner?
Petitioner number 1.
1.
1.
24/4/2023.
Yes, ma'am.
Insofar as the other petitioners are concerned, that is petitioner number 2 to 5, NBW was issued on 4/5/2023.
No, my lord. 24th of May 2023.
24th May 2020.
Yes, ma'am.
Okay. First, all of them were on bail. First, 5 of you, 500 each.
My lord.
34.
May I please, your lordships? Your lordships, NBW has been issued on 28/2019 and the petitioner was on bail since 14/12/2017.
14/12/2017.
Your lordships.
NBW is
28/2019.
19. How many of you are there?
Sole accused, your lordships.
Give 1000.
Your lordships.
35.
Obliged, lordships.
35.
35 ରେ କ'ଣ ଅଛି?
138 in 205 petition rejected ତାକୁ challenge କରିନାହାନ୍ତି only NBW କୁ challenge କରିଛନ୍ତି.
ତେର ରଖିଦିଅ ଦେଖିବା ଆସୁ. Yes. 36.
36.
ଏଇଟା କ'ଣ ହେଇଛି?
ଏଟା ବି ସେମ୍ ସେଇ
138.
ସେଇ
ଚलो ଠିକ ଠିକ.
ସେ ଗୋଟେ କାନ୍ସ
ରଖିଦିଅ.
38.
37. Adjourn.
Sorry, question.
Yes.
Compromise.
Yes, 38. Nobody appears on behalf of the petitioner. In the interest of justice, adjourn.
39.
Nobody appears on behalf of the petitioner. A service is party.
Somebody appearing by the opposite party.
Who is appearing?
Ramesh Agrawal. And R. Rajgaria and Das. For opposite party.
You are
Your
there.
Lordship, yes, Your Lordship. The brief has been transferred. Our name may be deleted, Your Lordship.
You are for
Informant, Your Lordship.
opposite party number 2.
Yes, Your Lordship.
Uh,
The brief has been transferred from us.
None appears for petitioner. Mr. So-and-so appears for opposite party number 2 and submits that the client has taken brief from him and he is no more appearing in the court and no more appearing in this matter. His name may be dropped.
Okay.
You are
Item 39.
39.
Yes.
Next. 40.
My appearance.
Appear.
May please, Your Lordship. Lordship, modification of order, Your Lordship. Only PS case number and GR number would be.
PS?
PS case number and GR number may be corrected.
What you have written?
Malgodam PS case number.
PS case, Malgodam PS case number 162 of 23.
Instead of 163 of 2.
Huh?
163 of 23.
162, 163.
My lord. And GR case number also 616 of 23, 617.
616.
My lord. Or 617 of 2023.
I recognize the order. Where from he got it?
Lordship, two serial names were there, Lordship. Case and counter case, both case was quashed, Lordship.
Oh.
When both order, one case, both case mention hai.
If
Then para 5 of the order in this case,
sorry, item 14,
minors.
just see item 14, order dated 17/1/2024, in place of PS case number 162 of 23, 163. ठीक है जी और GR केस 616 जगह 617
617
ठीक है जी 617 की 616 हो और PS केस हो
162 हवा 2 हवा minors
162 हो
3 जगह 2 हवा
इधर चेक करो ठीक है ओके
para 5 of the order
allowed
obliged.
I beg your pardon, your lordships. Your lordships, on behalf of Learned Counsel, Mr. S.J. Maharti, item 35 and 36 may kindly be passed over. Please be
Already passed over.
Obliged, lordship.
Item 41.
One है जाइए 8 तक 3 हो ordering person. Lordship, page 15 Lordship, the PS case kindly have a glance.
81
81 हवा
31 80 भी लिखा है माने
31 लिखा है आगे para 1 and 7 रे Sambulpur Moda PS case number 81 of 19 hava instead of 31 and 19.
in the petition also you have not written.
No,
That's the problem.
Mindless.
Petition where have you written?
PS case.
And you see the FIR, it looks like 31 only.
Yes, PS like
31. It looks like 31.
It 81
PS case 81 हो 31 लिखा है.
In para 1 and 7 of the order.
ठीक है.
मेरा 81.
81. 31 हो गया.
Statement रे 81 है चीज. 162 page 46 others में पेज दे.
सब
से देखी टाइम लिखती हो ना.
Mindless.
Not a problem. Anyway, 81 है जो.
Mindless.
31 जगह 81. ठीक है.
Obliged.
What is the formal writing? Anonymity is for petitioner in the interest of justice. 44.
Please, your lordship. Lords, here, the petitioner, my lords, has challenged order of cognizance, my lords, taken under the Prevention of Money Laundering Act. My learned friend has filed a reply, my lords. I require a short adjournment so that I can file a reply to that.
He was waiting for you since morning, Mr. Agarwal. In the request of Mr. Devasis for that, also for the petitioner, adjourn the matter.
That interim arrangement.
Interim arrangement can continue.
Your lordship may fix up a short date, my lord, because
give-
of
give
this
it.
interim order is not appearing, their trial court is unable to
Give
proceed,
it
my
short.
lord.
6th May. Yes.
45.
May it please, your lordship. My lord, in 45, the petitioner happens to be the brother-in-law of the opposite party.
Okay.
The petitioner prays for quashing of the domestic violence case that has been filed against the brother-in-law. My lord, with respect, my lord, it is not required to mention before this honorable court that starting from Kirti Gupta and many other judgments, the honorable Supreme Court has said that it has become a fashion to add the in-laws.
Everybody.
My lord, your lordship may kindly see why I have...
We're staying in the same house.
No, I have never I have said, shared household, no point of time I
That
have...
is one of the requirements.
That is one of the requirements. And this is filed on 29/4/2017. An FIR was lodged on 30th of January 2017 before this PWDB case. In FIR, nothing has been said against me. Police investigated, submitted charge sheet. I was not in the charge sheet. Then
That was when?
that is your lordship. That
No,
is
no, give-
the date is the FIR is on. Your lordship may kindly see that is the whole reason it appears to be.
Give me the date, sir.
FIR is on 30th of January 2017.
30th January
2017.
17. And charge
This charge sheet submitted on that is 24/5/2017.
24/5/2017.
2017.
And this DV case?
DV case filed that is on 29/4/2017. 3 months after the FIR.
Right. Who is the complainant in the FIR? Same.
Same.
That is
Opposite
four,
party.
number 4.
Opposite party only sole opposite party. Sole opposite party.
Two opposite parties. Acha.
Again.
Opposite party number opposite party, the sole opposite party had filed an laws and FIR on 30th/1/2017, January 2017. Inter alia alleging the matrimonial alleging offences arising out of the matrimonial discord, wherein the petitioner is the brother-in-law of opposite party number 2. First letter.
Opposite party.
Opposite
Because
party.
it PWDB case only.
Opposite party. Yeah. Alleging dowry torture, etc. against all the in-law, against her husband and all the in-laws except the present petition. Except the present petition. After investigation, even the charge sheet was filed on 24/5/2017. 17 against all the in-laws, barring the present petitioner. However, after 3 months, a DV case was filed on 29/4/2017. 2000. Why you were waiting for such a long time?
That again transfer है कि असला previously one before SDM Sambalpur. एबे ही notice मत ऐसे.
Making allegation against the present petition. Against the petition. It appears that the story, the letter counsel for the petitioner submits that the allegation made against the present petitioner are constructed and he had no domestic relations with the petitioner because he's not staying at no point of time when he was staying under the same roof. Therefore, DV case against the petitioner is not maintainable. Issue notice to the opposite party number 2.
Opposite party.
Retainable so and so. In the meantime, proceeding in DV case na.
Again.
DV proceeding in CRL MC bracket domestic violence number 110 of 2017 converted to DV miss case
Again.
number 44 of 2021 for the present petitioner is stayed.
Pending in the court of law and SDGM Sadar Cutoff.
Pending the court of law and
সেটা notice to opposite party only.
Only opposite. Yes.
Obliged, madam.
46.
I'm preparing for opposite party number 2 today.
Yes.
So sometime kindly.
Opposite party number 2, you are to.
Wait, please, Your Lordship. Some time may kindly give him time file counter to.
Ballot on the last occasion directed me to obtain instruction whether the case which was filed before the apex court is still pending or not. Last order is ballot 22/3/2024, wherein ballot opposite party responded there, file counter, case has been adjourned for hearing. Last order. We done it. If
So shall we await this outcome of this?
Ballot?
Shall we await the outcome of this?
Yes, ballot. And till that day, ballot stay at least. My lord was of the opinion if the case is pending, then I will consider about the stay.
What do you say?
Stay for the
pending
proceeding.
before Supreme Court.
They are ballot the witnesses to the marriage certificate. They have been taken as accused. Husband, my lord, this Akshay Naik is the husband, whether he will be held responsible.
The case under 494 by 109 of the IPC. So these petitioners are the witnesses to the
Marriage certificate.
for this marriage officer. So they are the material witnesses. And main actually.
Yes. It is
the passing of the cognizance will be paid.
Cognizance with regards to 498A, 494, that is against the husband only. It is the other.
So I counted to the captain.
The other counter.
Or short that the counter.
But that SLP is pending then what?
Yes.
Right up. Right up. One of the co-accused person in the instant case had earlier approached this court by filing CRLMC number 2329.
Who is the husband?
2329 of 2021. The said accused was husband.
Ballot.
The said accused is the husband of the opposite party number 2. The coordinate bench, by the order dated 2/2/2023, has been pleased to dismiss the said petition. Against the dismissal of the said petition, the accused, the said accused, filed SLP's criminal D number 18666 of 2023. The Honorable Supreme Court, by the order dated Honorable Supreme Court issued notice to the notice in the said SLP, Mr. Dhar, appearing for the petitioner, place on record the proceeding before the Honorable Supreme Court, Honorable Supreme Court. Since the proceeding before the Honorable Supreme Court is pending, it is a direct bearing on the present case. The petition is
In this case, no prayer has been made to pass and stay order.
Oh, there.
There is.
And awaiting the outcome of the SLP, so and so, SLP, 186623, matter is adjourned to such and such time. In the meantime, proceeding before the court so and so is stayed.
Launch.
Yes.
47 that, 2 weeks after us. But
40?
just next item, 47.
47.
2 weeks after, the interim order may continue.
Interim order to continue. Anybody else?
Item number 38, it just passed over. I have.
Passed over will be taken up. Any adjournment?
No.
Adjournment.
My lord, in 48, my lord, item, OP number 2 is the informant is appearing.
OP number 2, Lordship.
So-
Today I am filing the Bokalat now.
So and so entered appearance 42. So and so entered appearance on behalf of opposite party number 2 and 6 times to file a response.
My lord,
Taken on record. Matter is adjourned.
my lord, I pray for next week to come with a joint affidavit, but it's ready to come from.
They have- you have
No,
settled
on
this-
Thursday, yes, my lord, on Thursday, my lord.
Settlement next week.
Settlement case. Can it?
Okay.
Settlement between the parties. 2004 matter.
Today is listed.
No, no list. Monday.
But it will be listed then only. What is the offense?
2004 matter.
2004, what is murder?
No.
Then
306.
306.
ସିଏ ତାର ସୁଇସାଇଡ୍ କଲା
ହଁ।
ଯେହେତୁ ଏନିମିଟି ଥିଲା ଭାଇ ଭାଇ ଭିତରେ
You give the
Monday ପାଇଁ so that both the party.
Monday 306 it has to be seen.
No,
The state has to.
ନାଇଁ ସାର୍ 2004 matter.
Mr. Maharaja.
ସାର୍ ଆମେ ହସ୍ପିଟାଲରେ ଥିଲୁ. That is on record.
Whatever, you want to argue on merit, then just
No,
settlement 306, you give it, we'll see. Then take it.
And one modification of lordships.
What modification?
13/3/2024.
No, what is the modification?
Some modification is required.
Typographical error.
No. Because your lordship has last.
I might have given you the liberty to appear before the court
No,
below, and court below might have rejected it. Now you want a modification.
No. That has not been rejected. The learned court below saying that you give the original records. One from I will get the order. Yes, Hon'Ble.
Like 48 days to 22 को नल 24
The side of informant minor. File also objection minor order of money with Sibo. ମୁଁ ଭେରିଫାଇ କଲି ସେଠି ରେକର୍ଡ ରୁମକୁ ଯାଇଛି ଜଷ୍ଟ ରେକର୍ଡ ଅନଲାଇନ ଆସିନି ବଟ ଅନରେବୁଲ କୋର୍ଟ ଡାଇରେକ୍ଟେଡ ବିଫୋର ମି ଯେ ଏଇଟା ତଳ କୋର୍ଟ କନସିଡର କରିବ ଫାଇଲ ଆପଣ ହଜିର ମନେ ବି ଥିବ ବଟ କେସ୍ ୱାଜ ଆଲାଉଡ ସବଜେକ୍ଟ ଟୁ ପେମେଣ୍ଟ ଅଫ 500
ସେଟା ଆଲା ହବନି କଣ ବେଲଜିୟମ ଟା ଆଲା ହନ୍ତାନି
ଅନରେବୁଲ କୋର୍ଟ ଯାହା କୋର୍ଟରେ ଅର୍ଡର କଲେ ସେଟା
ଆମର ସେଇ ଅର୍ଡର
ଆପଣ ଚାହୁଁଛନ୍ତି
ନାଇଁ ଆପଣଙ୍କ ମାଇଲର ଡାଇରେକ୍ଟେଡ କରିଛନ୍ତି କହିଥିଲେ ଯେ ସେଠି ତଳ କୋର୍ଟ କନସିଡର କରିବ objection but allowed subject to payment of a 500 rupees cost.
ଆପଣ ଅବଜେକ୍ସନ ଟା ଲେଖା ହେଲା
he will appear and move application he oppose there
ନାଇଁ ମୁଁ ମୋର application ନାହିଁ ସେଠି ଲେଖା ହେଇନି ଡାଇରେକ୍ଟ ଲେଖା ହେଇଛି 500 each cost.
note down the number
Your lordship passing the usual order, my lord. Belgium matter, your lordship passing usual order.
ତାଙ୍କ ସବମିଶନ
While passing the NBW, your lordship directed surrender appear before the court.
order start ଡାକ୍ତର କଣ କହୁନ ଦେବ
anyway we'll just see
ସେଟା କଣ ବୋଲି
ନାଇଁ ଏବେ ଜାଣିନାହାନ୍ତି
anyway
ଯାହା ଓପନ କୋର୍ଟ ଅର୍ଡର ଡିକ୍ଟେସନ ଅଛି ସେ ଲେଖା ଆପଣ ଶୁଣିଛନ୍ତି
it's all right the number ଟା
ଅଛି
I just see don't worry
I may be part of
honorable court dictated in the court you file objection before the trial
I'll
court.
just see give the number I'll just see
I may be pardoned to make an unusual mention.
କହିଦିଅ upload କରିବ ମୁଁ ଦେଖିଲା ପରେ upload କରିବ ଠିକ ଅଛି
I may be pardoned to make an unusual mention, my lord. It's a matter where, my lord, remember the POSCO matter, whether based on the settlement between the parties, a case can be quashed. In the particular case, my lord, the victim, her mother, all appeared, and the mother also appeared through virtual from the concerned police station. And there, my lord has passed the final, kept it for judgment. Now, the police is chasing me, and there, my lord has said no coercive action against the person. That was the specific order of this honorable court, but that is not found in the order of my lord. That is the reason for which I have consistent to
this
fight.
is listed today
No, it has been kept for judge. Tomorrow, obliged. I have filed a specific IA for that.
My lord, item 15, today's list.
yes sir
My lord, I have requested my friend
I
pass over.
Let's see, my lord. That senior work was approved to me to
what happened that
regarding not a pure urgent, my lord. Whenever I am writing to I don't know,
Maybe taken up
in
my,
that this item has been passed.
my lord, kindly be taken up.
order already order signed no not signed not signed let pick up no problem
Oh, bless.
Pardon to mention, your lordship, on behalf of Sarveswara Behera, item number 88, kindly take one.
mentioning at 2 o'clock I don't entertain unless it is very urgent wait wait I don't and who all are they
special notice
huh?
special notice matter
special notice matter I madam I just do that matter because the parties are there I have to finish yes which item is that
But a special
PP
311
311.
offense
My lord, offense 376.
6 also
Yes, 363, 366, 376. 2N.
who is the informant
My lord, informant is the mother of the victim. Victim is 14 years old. My lord, what has happened? He has
where is your application 311
311, my lord, that is annexure 4. Let me verify.
now
There is
read that
something.
question read the question as move
My lord, she filed a petition before the learned trial court. ମୁଁ ମୁଦାଲା ଘରେ ମୁଁ ମୋର ଥିଲି ମୁଁ ସତ୍ୟ କଥା କହିପାରି ନଥିଲି ମତେ ଅନୁମତି ଦିଆଯାଉ ମୁଁ ବର୍ତ୍ତମାନ
whose application is this
এটা this is filed by the victim herself.
he wants to resign
My lord,
already statement she has given the
statement she has resigned. My lord, what has happened? FIR 161 statement. My lord, that is one line. But after 164 different, before the court different, according to her, she was forced to give such evidence.
who are you
I am the, my lord, petitioner is being represented by her sister because mother and father, because of the threat, they are not coming forward. They are also with the accused.
no the application 311 application
Application has been filed by the PP.
for recalling this witness
After getting this letter, She addressed to Mananiya Posco Judge, Bhavani Patna. ମୁଁ ମୁଦାଲା ଘରେ ମୁଁ ମୋର ବୟାନ ବଦଳାଇ ଦେଇଥିଲି। ମୁଁ
And who are you? You are the.
I am right now, she is before your lordship, being represented by her sister.
Why the PP is requiring her to come once again?
Because
whatever.
Because he has stated there that
your lordship may kindly turn to page 23. That petition has been filed by
that I am looking at. It is filed by the special PP POXO.
Yes.
Varipatna. And he wants to ask this. Ghatna samare tomar boyso kete thila? All this question, how can you ask once again to the victim?
Because right now the entire thing has been my lord offset total. What has been stated in the FIR in the 161 statement has been given a turn after the statement made under section 164 and also before the court. Soon thereafter,
she has not supported the prosecution.
No. According
she was put to she was subjected to cross examination.
She was subjected to I have filed, my lord, your lordship may 164 टा मु देइछि आरोटा देइनि 164 रे कहिला आपण देखंतु
yes I am
page 20 page 20
please read it, let us see.
मु आपण को आगरे सत्य बयान देउछि मु जने पिला सह कथाबार्ता हुए ता ना मंदर सुनानी मु दिने ता सहित 17/7 संडे ता भौणी घर को बुलिया को जाइतली मु घरे कहि नथिली मो घर खोजा खोजी कले मु फोन करी कहिली जे मु एठारे केरांडी रे अछि तमे व्यस्त होनी मु काली जीवी मो बापा जाई सेठारु मते आनिले घर लोके मु पळेइथिली बोली भाबी केस देइथिले मु निज इच्छा रे जाइथिली
164 also nothing said.
Not but
and you want the same witness to come back to support you.
But she filed a petition. I am with the victim. Victim is before your lordship.
I understand.
Yes, victim is before your lordship, but your lordship may kindly turn to page 17.
And where is the MP notice?
Page 17. Page 17. Her statement. मो ना सोआनसो सोआन मु सरकारी प्राथमिक सिरलीगुड़ा रे पंचम जाय कस्तूरबा गांधी आवासिक बालिका विद्यालय अष्टम पर्यंत पाठ पढ़ी आम गाँ रो मंदर सुनानी मते भल पाए और बाहा हबो बोली घरे
164 you have already read.
164 just the reverse.
But victim and victim mother has already they have been cross-examined.
They have been cross-examined.
Cross-examined, and it's the contention of the defense counsel that it has already been elicited from the mouth of PW1 and PW2 that the accused have never kidnapped. My lord, the running page 28, the order of the rejection, my lord.
Yes.
My lord, order of rejection, I am challenging only on the ground that since she is 14 years old and has been put to some threat and which has been disclosed thereafter before the court itself. So, by giving her one chance will not prejudicially affect the prosecution. Rather, it may lead to a judgment which will be beneficial to the victim, because these cases are arising.
You must be supporting?
Yes.
Are you supporting?
He has to support because that has been filed by the PP.
My lord, the order reflects that the special PP is misconceived and
the problem is 33 clause 5.
Yes, my lord.
I will allow insofar as mother is concerned.
Mother. But mother.
PW2.
Well, mother is in the grief of the accused.
That I can't help you.
Only, my lord.
Can't help it. Write down. The petitioner is petitioner is who?
My lord, petitioner is the victim being represented by. Right now, she is not staying with her parents. Right now, she is staying with her elder sister.
Anamika Durga is the victim.
Victim, 14 years old. because her mother and father didn't support her. See, right now she is staying with her sister, and it is being filed by the sister.
This is very, it is something dicey, I tell you.
No, that maybe, my lord, but there are threats.
She has not supported the prosecution earlier.
Earlier she has.
Now she wants to wriggle out of her own statement.
My lord, my submission, your lordship knows what has happened in the rural areas, and if there is threat.
She keeps on changing herself.
My lord, that's
Sometimes in 161 something, is 164 something,
that-
again in the court something, again you will recall it,
because
say something else.
my lord, because of threat and pressure, your lordship knows that. And if these type of crimes are in rise.
Right on. The special PP POCSO moved an application under section 311 CRPC seeking recall of two witnesses, namely PW1, the victim, and PW2, the mother of the victim. The said application turned down, na?
Yes,
Said application
rejected.
has been rejected by the additional sessions judge come special court under POCSO by order dated 6/2/2024. The present petitioner, the victim, being represented by the
by her elder sister.
By her elder sister, have assailed the said order. Assailed the said order. The victim was examined under 161 CRPC by the police and subsequently under 164 CRPC as well. She has not supported the prosecution in her statement under 164 CRPC. Similarly, when she deposed in the, she has deposed in the court in favor of the accused, not deposed in the court, not supporting the prosecution. Therefore, the learned PP has moved an application under section 311 CRPC. In view of the bar under section 33(5) of CRPC, I'm not inclined to entertain this petition. I'm not inclined to allow, I'm not inclined to alter the order of the impugn order insofar as PW1 is concerned. PW1 is concerned. Mr. Rahul appeared for the state that submits that he too is aggrieved by the order of sessions judge declining to recall the witnesses. Taking into consideration the particular facts of the present case, I'm inclined to partly allow this petition and partly allow the petition and application of the special prosecutor under section 311 insofar as PW2 that mother of victim is concerned is allowed. She should be recalled by the court below and give a singular opportunity to be cross-examined before the said witness is recalled for cross-examination. The proposed question shall be filed. Proposed questions to be put to the said witness shall be filed by the prosecutor before the court below, and the court below shall examine the relevancy of the same and afford one single opportunity to the prosecution for re-examining the said witness.
Obliged.
Yes.
Urgent copy of your.
I prefer adjourn this.
Sorry.
Urgent copy of your lordship.
I prefer adjourn this matter 4 weeks.
4 weeks.
হয়তো ମୁଁ ଛାଡ଼ିଦେବି ପାରେ କେସ୍ ଯଦି ତାଙ୍କ ଯଦି ସବୁ ଠିକ ଠାକ ନ ହବ ଛାଡ଼ିଦେବି କେସ୍ ସେଥିପାଇଁ 4 weeks
See, in the morning you said that today only you take it up. I
I may
brought
sleep
it.
My lord, I am
Don't do all
for-
these things.
for-
Don't do,
for-
without verification, never do those things.
Lower court or advocate କଥା ଚାଲିଛି।
It sends a very bad message.
ଭଦ୍ରଲୋକ ପାଖରେ ୟାଙ୍କ ପାଖରେ ନାହିଁ ଏସବୁ ମୁଁ ସବୁ ବୁଝିଲି।
Lot of litigation. I understood the way these people behave.
Sir, for each time.
Adjourn kar do.
Sir, entry one.
Whatever entry more. Yes.
Item 18. Item 18.
Yes.
May I please, Lords? In this case, the petition is a private limited company, my lord. The petition number 1, my lord, represented the company as a CEO at 18. Petition number 1 is the CEO of the company. The petition number 2 is the manager of a office of the company at Bhubaneswar, my lord. And the complainant, my lord, the opposite panel 2 filed complaint petition before the District Labour Commissioner Raigada, my lord, alleging that some wages had not been paid to him while he was discharging his duties.
52 payment of wages.
52 payment of wages act. That is under Mr. Your Lordship, I'll have a glance. Page 17, man.
What are your grievance?
Then what happened, my lord? Before the Labour Commissioner, a settlement was arrived at, and both parties agreed to settle the matter at Bhubaneswar office, my lord. And at Bhubaneswar office, the petitioner number 2 and a complainant both presented and concluded a settlement. But thereafter, my lord, the complainant did not turn up and insisted upon the learned commissioner, my lord, to refer the matter to the magistrate, my lord. And the magistrate, my lord, after received the report, my lord, took cognizance under Annex 1.
What can I do?
No, because, my lord, in the meantime, my lord, what happened, my lord? The petition number 1, the head office is at Hyderabad, my lord. And at Bhubaneswar, branch office is functioning. And the complainant residing at Cuttack, but he filed petition before the District Labour Commissioner at Raigada, my lord. And at this juncture, my lord, if the petitioner and the 1 and 2 are not protected, my lord, then NBW must be issued, my lord, because
No,
of
I
they are
can't, on your apprehension, I can't pass the order. So many things may happen. How do I know? May not happen also.
Petitioner agreed, my lord. Both the complainant also agreed.
There, because your logistic problems I can't take care of. Because you are staying, there is no bus communication, train communication, I can't come. All these things in a 482. What can I do?
Only protection may be given, they may be allowed to appear there.
What you
protect.
appear? Shall I record that on or before 15th of May, you will appear and seek remedy?
Remedy, but in the meantime, I had, my lord, the magistrate,
This is not a bail court, sir. This is the 482 court. Either you satisfy me, I'll quash it. If you you can't satisfy, then I'll dismiss it. As simple as that.
I'm bringing that.
You may be arrested. You may not get bail. Therefore, I'll give indulgence. All these things.
My lord, here, my lord, because I'm on merit, my lord, I'm just submitting for Lordship, my lord. Lordship for movement kind of
The petitioner is an accused. Petitioners are accused in 2CC case number 14 of 2023 and initiated by the opposite party number 2 under section 15(2) of Payment of Wages Act. When the conciliation failed, a report was submitted and thereafter the magistrate, thereafter the court below has taken cognizance of the offences. Offended. Learned counsel for the petitioner through this petition seeks to challenge the order dated 11/5/2023 passed by SDJM Raigada, whereby cognizance of the offence has been taken. I'm not inclined to interfere in this matter at this stage. At this stage. However, the petitioners seeks indulgence of this court, seeks liberty from this court to raise all the issues before the court below, after surrendering to the jurisdiction of the state court. On instruction, he submits that the clients would be appearing before the court below on or before 15th May, on or before 15th May 2024, and move appropriate application permissible under law, and seek remedy and seek remedy. The petitioners are granted the safe liberty to surrender to the court on or before 15/5 also. Till then, no question.
Lordship may fix to 23, my lord. 23 because the
30th में कर दो. On or before 30th में जाओ.
Obliged.
You appear.
My lord, what happened, my lord? I learned from reliable sources. The Lord and Master already issued NBW, my lord. That is fixed to 24th. So 22nd, your lordship may.
On or before 30th May, I have done it. You go.
Yes, my lord. Lordship
anytime in
protected.
between.
Yes, my lord. Obliged.
Yes.
Urgent copy.
35.
Yes.
But on Mr. Mohanty, he was there, he left for some other particulars. 35, 36, both were passed over.
Urgent, 35, 36.
No, it was passed it over, Mr. Mohanty was there.
No, today lot of matter I can't.
Yes, it was then page 8, the impugn order.
Actually, you want to argue?
Yes, that Belgium matter, madam.
Belgium matter.
Not Belgium. In fact, the cases involved 13010 Act. Notice was issued. And despite service of notice, he did not prefer to appear. Initially, BW was issued, then NBW was issued. That is another challenge.
Won't appear.
2055 reject challenge करना थी warrant actually.
The petitioner is accused in 1CC case number 140 of 2020. Under section 138 NI 138 NI. The petitioner appears to have moved an application 205 CRPC, which has been turned down by the trial court, and NBW was issued. On instruction, the petitioner submits that he would be appearing before same controversy also, and seek remedy available to him under law. And kept in events. NBW issued on 11/10/2023 kept in events till 15th May. So and so, with subject to the petitioner appearing before the court and seeking remedy available. Okay, next 30.
36 also same, my lord.
36 same.
Say 13010 Act matter, but different. Another case. BW, then NBW. That.
No, this is also 138.
Yes, 13010 Act.
And IGC case number change कर दो.
Case number is 2.
Okay, next. 52.
30.
Lordship. I am for the informant, my lord.
Yes.
I filed one miscase to recall that order, my lord. I filed one miscase number 374/24 to recall to order dated 6/2/24.
6/2/24.
My lord. The factual matrix of the case is
Only
that
what have I said here? That
on the basis of aforementioned facts and submissions, the order dated 4/12/23, para 4, by the Lord James Loisinga in their case and such and such.
I have only cancelled the NBW.
Cancelled,
and asked him to appear before the court.
They are already go on bail, my lord. They surrender and already the accused bail went on bail.
So you are agreed by that?
Yes, ma'am. I am for
challenge that. Where is the question of modification? It has already been executed.
Because I am the informant in this is a 376 case, my lord.
It's all right. NBW was issued. And I only said that NVW is stayed and you go and appear before the court on or before 25th February 24 and seek remedy as available under law. He appeared and moved an application. Trial court has granted bail. If you are agreed by that bail order, you challenge that order.
With due respect, my lord, the petitioners have suppressed some things, my lord. Suppressed some facts before the Solemn Court. Lordship Lordship kind of glance to Annex 3, page 26.
What is the, you tell me.
Because prior to filing this case, the accused persons moved for maybe one revision before the sessions judge. That has been rejected. And during pendency.
All these things, when the bail application was heard, you should have argued, no?
Your lordship. Your lordship.
You should have argued.
Some facts has been denied. That is why I came because
that's right. But see, this is a routine order I pass. If NBW is issued, I only permit the accused persons to go and appear before the court and avail remedy. I just give that breathing space.
The accused was already appeared in court below.
You challenge that order. You challenge that order. You challenge that. Simply withdraw. No? You challenge that order on the ground that suppression, recall that order.
Okay. Your lordship, that's
yes.
That was also passed on.
No, non-appearance.
That is urgent. Nobody was there.
I was mentioned before count.
I don't know. You people are anytime you can come to the court and sometimes somebody is mentioning and all. There will be some system to be followed.
That order may
next week, 38.
Item 52.
I for extension of time.
I don't know why people are so casual. Why you were not there in the morning? Yes.
I can say that I am liberty to move appropriate forum as per law after seeking my remedy. 52. I
52. Let us go for the petitioner seeks to withdraw this application with the liberty to approach the appropriate form challenging the order dated
6/2/24.
6/2/2024 passed by
challenging order dated 4/12/23. Sorry,
4/12/23 passed by
JMFC Loisinga.
JMFC Loisinga. With this liberty, yes. What extension of what? 38.
Only extension of time. Period of 2 weeks.
Huh?
Only extend the period of surrender, date of surrender. Last occasion extended, but due to communication here, because of they are living interior area of Malkanagiri, they could not avail the order passed by this honorable court. Can you extend 3 more weeks to communication surrender?
You are supposed to appear on
27.
Huh?
Order was passed on 29/2/2024. 3 weeks time given, but in that period they could not present before that honorable court.
Where is which paragraph?
Paragraph 6, my lord. Considering the submission made by the learned counsel for the parties, the order dated 27/7/2022 is modified to extend that petitioner on surrendering before the court in session over the matter within a period of 2 weeks from today.
Right. By order dated 29/2/2024, the coordinated bench of this court granted 2 weeks time to the petitioner to surrender before the court below and court below and avail remedies under law. The petitioner is moved this application for modification of the said order and seeking extension by way of seeking extension. How further forward?
4 weeks, my lord, because
petitioners, the application is allowed. Petitioner is directed. Petitioner How many time it is modified?
This is second application for modification. First occasion, that was could not communicate because heavy rainfall was there, and there.
So the High Court is only for you. We'll keep on moving application and we will keep on.
Only 2 weeks time.
Now I'll impose cost. Extend but impose cost.
That was
Further,
extended.
the
My lord,
time period to surrender.
Cost was there.
Surrender.
That of 20,000 was imposed them. For that reason, they could not avail the order since 2022.
May I please, madam?
Yes.
Let's application for modification of order dated 2024, madam. Here's the petition has prayed to extend the date of surrender.
The senior is sitting there. Maybe.
I'll call next time.
Yes.
Let's see if the petition has prayed to extend the date of surrender.
Why?
Let's see, couldn't appear, my lords, due to illness.
Yeah, by order dated 20th to 2024, the petitioner is directed to surrender before the court on or before 12th March 2024. He seeks extension of time. The time is extended up till 15th May 2024 for surrendering of the petitioner and seeking appropriate remedy on the law. Yes. Yeah.
55.
55. Yes. What is that? Yeah, Mr. Non-APS, urgent. Huh? Non-APS for the petitioner, even the last order has not been complied by the petitioner. In the interest of justice, urgent. May record this.
56.
56, my lord, I pray 2 weeks time. That a talk of compromise is going on.
Urgent to
Interim order.
yes.
57.
May I please, your lordship? My lord, I'm appearing on behalf of opposite party number 2, who is the complainant in this case. I'm filing the wakalat number.
Shown to enter the appearance on behalf of opposite party number 2 and 6 times.
My lord.
1 week.
2 weeks, my lord.
2 weeks time to file counter. Urgent to sound.
Enter to continue.
Entry want to continue.
Obliged.
58.
Yes, my lord. I'm filing for quashing of proceedings. They found that they're married to each other and married to each other, petitioner and victim, and blessed with a child.
Sure.
I'm approving for the.
Name is taken out of the court. And affidavit also.
And for the victim process.
Victim. Don't to appear for victim and file proclamation and affidavit, which is taken out of the court. Leave the matter.
In fact, my lord, no case is made out. As per the
I'll
statement of the-
consider that. Leave the matter for this. Next week, I'll do that. First week.
Second week. 59.
My lords, this is an application for cancellation of bail. That, my lords,
When
30
bail was granted? 1 year back.
my lords,
1 year back.
my lords,
25/1/2023. What are the offences?
307 is there, my lords.
Okay, bail granted.
Head injury is there.
Maybe.
My lords,
Discretion I will not enter.
no, my lords, the learned court below, my lords, biased by the submission of the accused petitioner.
Whatever discretion is exercised, why should I interfere in a bail matter after 1 year? The petitioner is the informant in the present case. Seeks indulgence, challenges the order dated 25/1/2023 passed by additional sessions at Baleshwar in bail application number 51 of 23, whereby opposite party number 2 and 3 has been enlarged on bail. The account for the petitioner submits that the concession of bail granted to the opposite party number 2 are not sustainable under law, in view of the fact that the court below has not taken into consideration the materials available on the court. I'm not inclined to interfere in these matters because the
Without verification of the record, injury has been stated to have been simple in nature.
And the petitioner, the opposite party are at opposite parties have already been enlarged on bail on 25/1/2023. 23. And there is no complaint regarding the misuse of the bail condition. If misuse of bail condition, see, 2007, 307, every day we are granting bail. If the sessions court gives bail and you challenge that, we are discouraging basically the court below not to entertain application to start interfering. And 1 year back, bail was granted, more than 1 year back, January 23.
Immediately I challenge.
If they misuse the bail condition, and you can move application for a cancellation, not on the merit. Okay, next. 60. Here.
Enter my appearance for the opposite party number 2, my lord. I'll file my counter.
Mr. Chan and this appearance on behalf of the party number 2, it's time to file counter. Release the matter. Non-APS for petition. 62.
May I please, Your Lordship?
Yes.
This application for bail. After conviction, he has preferred the appeal.
Why it has come to me?
No, CRLM. Because I have preferred the appeal because of my sentence is 7 years. I have to prefer the appeal before the learned session judge. After appeal has been admitted, the bail has been refused. For that reason, Your Lordship, I have preferred the CRLM. Nomenclature is CRLM. Otherwise, this is an application for bail.
Yes.
So, Your Lordship, state will come to page of mine 10 of my brief.
Yes.
After he has been apprehended, he has been released on bail. He has been apprehended on 8/12/2014. He has been released on bail on 29/1/2015.
Where are you reading? Where are you reading?
Page 10 of my brief. In judgment, that has been reflected.
10 is Form B.
Form B. Thereafter, accused details. Thereafter, 1. Ganeshwar Tribune.
You are the petitioner.
My lord. Date of arrest, 8/12/2014. Date of release on bail, 29/1/2015.
What do you want now?
My bail application has been turned down by the London court below, while the appeal has been admitted.
You are convicted.
Yes, I have been convicted for a period of 7 years.
389 benefit is not available to you.
My lord.
3 years.
Wow.
Why are you taking this way? 389 benefit is not extended to you.
Extended to me.
It is more than 3 years. Simply say that.
My lord.
On merit, let us see if you have how much you have undergone.
That is from the date of judgment.
First, here about 1 month.
Immediately I have been released on bail. I have never violated.
You have undergone only 1 month.
1 month. I have never violated any terms and conditions as imposed by the during course of
Yes, Mr.
Maharaj.
Yes.
There are evidences in there.
Oh, therefore he is convicted.
My lord.
1 year undergone. Only 1 month. 1 month. Now you are in custody.
My lord, I am.
When you judgment is dated? नहीं नहीं हाँ that's what I was thinking. 24/11 2023 24/11 2023 कितने दिन है?
6 मास से
6 मास से आगे भी मास
7 मास से
8 मास
your lordship may carry me go there because I have been released on bail after going through the entire thing.
8 months. In any case, you see, appeal is by way of right. 8 months is already. He may be able to do more. I know. The petitioner is in the accused. In the case, accused in the the petitioner had been convicted by the court of assistant sessions judge, special track for Gonepur, by the judgment dated 24/11/2023 under section 376 1 and sentenced to undergo RIF
7 years.
7 years. 7 years. His application under 389 CRPC was turned down while admitting the appeal. Therefore, he is before this court. The petitioner is in custody since 24/11/2023. 2025. Mr. Das, let confirm petitioner submits that in all likelihood he will succeed in the appeal. Therefore, pending appeal, he seeks some suspension of his sentence. Suspension of Mr. Maharaja, accused of the state, vehemently opposed the prayer of the petition. Taking into consideration the fact that the petitioner has already undergone about 9 months custody, the sentence imposed by the court below, by the order dated, sentence order to the state. Sentence order dated also, he suspended during the pendency of the pendency of the pendency of appeal number कौन थी?
Appeal number by
Sentence hearing on sentence.
Yes.
Same day. Same day.
Same day.
24/11 in the afternoon. Morning conviction, afternoon sentence.
General appeal number 24 of 2000.
Sentence order dated 24/11/2023 passed by additional session judge SPC Sonpur. SPC Sonpur is suspended during the pendency of the appeal. Criminal appeal number
24 of 2023.
24 of 23 pending in the court of
Reliance session judge. नहीं assistant session judge conviction कल है.
Session judge.
Session judge Sonpur.
ठीक है.
Oblige.
63. Now he shall be released on bail.
He shall be released on bail.
Suspended. He shall be
released on bail.
On the terms and conditions to be imposed by the appellate court.
Trial court, my lord.
Trial court. As fit and proper.
Madam. Oblige. Fine, sir.
Yes. Look, this is a case where bail has already been granted to the petitioner by the Supreme Court. Well, only one of the conditions was that he is to deposit his passport. Well, look, he has an office in Bangladesh. They basically film producer. They are the biggest film producers of Bengali movies situated in West Bengal. They have offices. They have opened an office in Bangladesh, my lords, in Dhaka. So he has to travel on and off to Dhaka. My lords, he has taken the passport twice and has again returned it in correct time, my lords. And he has attended all the dates. Whatever dates have been...
was that the condition imposed by Supreme Court?
No, my lords. No. This was a condition. Supreme Court simply said that grant bail, my lords, your lordships may say page 99. this is these conditions have been imposed by the special CJM CBI. And my lords, your lordship.
Republic of India is seriously watching.
And my lords, your lordships had asked me to give an affidavit that I will intimate to the court whenever I am traveling outside, my lords. That affidavit also we have given.
You are agreed by which order then?
The order, page 99.
12/1/2021.
Yes, my lords. 12/1/2000. Case record is put up today on the strength of an
One minute, sir. Yes.
I'm
12/1,
sorry.
yes.
Page 99. Fourth paragraph. Heard both the counsels on application to enlarge petitioner Shrikant Mohta on bail through VC, my lords. Lordship. Peruse the order of the Honorable Apex Court wherein it has been held in para 2. Your lordship gets it? That in terms of the signed order, we order and direct that the appellant shall be released on bail subject to such terms and conditions as may be imposed by the special CJM CBI.
Then this condition you are agreed by.
But my lords, the conditions in the meantime, case record has been transferred to this court. Now the condition 3, my lords, he shall surrender his passport before this court and shall not leave the country without its prior permission. My lords, I am ready to take permission of the court, my lords. But my lords, the passport may be refunded every time I travel outside. My lords,
along with the permission, you ask for a passport also.
my lords, visa, I have to get visa also, my lords. I have to deposit the passport. That is my problem, my lords. And I have to travel frequently to Bangladesh and come back.
For visa, you want passport.
My lord?
For visa, you have to.
Yes, my lords. Then he's a film. He also directs films, my lords. Then suppose he has to go to Switzerland. Again, my lords, he has to deposit the passport. That is why the passport is necessary. Otherwise, and your lordships, every date we have been attending, my lords.
Yes, Mr. Nayak, it is
yes.
439(2) application.
May I
He
please,
wants
Lordship?
slightest modification in the condition.
Yes.
He says that he will be taking permission when he leave the country.
So I strongly oppose to it. I strongly oppose to it. I'll give the reasoning, Your Lordship.
Right.
And another thing before he starts, my
Yes,
lords,
yes.
the allegation against them was, my lords, the entire money is whatever the CBI has alleged is also now secure, my lords. What had happened? What is the allegation against the petitioner? The petitioner is a film producer, as I was indicating before, your lordship. Now, what happens, my lords? Real estate, this Rose Valley, they wanted to produce. They have a film channel, TV channel. So they wanted some movies to be produced and some serials to be made, my lords, telecasted. So they gave a sum of rupees, whatever, 25 crores.
Why should I consider? From office, I am satisfied.
Yes,
Okay. Let us see. What is it? The objections are serious, then I'll give.
No, what I'm saying is, my lords, whatever the amounts that were alleged, that have been alleged, I have taken from Rose Valley by way of, my lords, money trail. That money also have refunded now to Rose Valley in an account seized by the CBI. So the entire money is secured as per the arbitration award.
Your Lordships, Your Lordships, I had argued this bail application in the Orissa High Court. Kapil Sibbal came from Delhi. Sir was assisting Mr. Kapil Sibbal. This is a
He has
report.
a lot of money he has to pay to the lawyer.
This is a reported judgment. Your Lordships, Air Online 2020, Orissa 156. It's a 60-page order, Your Lordships. In all the paragraphs written how he has laundered money.
I am not interested in the merit.
Yes, merit. I'm coming to.
Supreme Court has granted bail.
Your Lordships, Supreme Court has granted bail. Investigation is not complete in this case, Your Lordships. Investigation is still going on. Investigation qua the petitioner is also pending. So when the investigation is pending, Your Lordships, 9,000 crore is yet to be refunded by the principal accused, Your Lordships. And when the 3 principal accused are still in custody, Gautam Kundu, Ashok Saha, Sibamay Datta. 3 of them are in custody. Money trail part is being looked into. Investigation qua the petitioner is not over, Your Lordships, because we are the investigative agency. Sir is saying that investigation is over. We have returned back the money. From where?
I'm not on that. See, condition.
Why should you go back, Your Lordships? Your Lordships, recently Supreme Court, I will give you order.
Why have you not challenged this order then condition?
Your Lordships.
See the condition. See the condition according to me.
Yes.
Condition number 3 is contradictory. In the sense,
yes,
it says that he can take permission and go out.
Yes.
And surrender the passport.
Yes.
If he wants to go back, go to any country, he has to apply for visa. He needs passport. And traveling for the purpose of traveling also, he needs visa.
Yes, Your Lordship.
Move twice.
Your lordships, he can to go 20 times, but whenever he goes, he will seek the permission of the court. He will give the itinerary.
He
will
says
follow.
that don't alter that. He says no
No, he
altering.
can go, your lordship, when the investigation is pending. I will give you a hypothetical example. For example, if your lordship, the investigation is pending, final charge sheet has not been filed. When the final charge sheet will be filed, for example, if it will be known that 50 crores more he has taken from Rose Valley and he is going to Singapore with his passport and visa and placing those money or tracing those money there, who is going to be responsible, your lordships? He will go to the court, he will give his itinerary, and he's an accused. He's not doing any charity by moving around when the investigation is pending.
No, that's right. You are absolutely right. But
For example, in future,
you are
nobody
not
knows, your
agreed
lordship.
by you are not agreed by this condition. You have not challenged this condition.
You know, why should we challenge? Once the condition is there that he is going to submit his passport, why should we challenge it? We want his passport to be submitted. And recently, one judgment, your lordships, I'm citing, same chit fund case, your lordships. Orissa High Court has granted bail. Supreme Court is saying that you go and surrender your passport. My junior will give your lordships. This is order dated 10/1/2000.
I'll slightly modify it.
I'm reading this order. For example, your lordship, for a moment, lordship, I pass any order. Let me read it. 10/1/2024.
Yes, yes.
The Supreme Court is saying that last 4 lines. However, we make it clear that there shall be a condition that the appellant shall surrender his passport before the trial court, if not surrender earlier. If he does not possess a passport, he shall file an affidavit in that regard before the trial court.
Now, what I'll do is, I'm agreeing with you. What I'll do is, I'll only modify this condition number 3 to the extent that whenever he required for the purpose of applying for visa, it should be made available to him. Because for permission, for going abroad, he has to take permission in any case. That condition I'm not altering.
But for that, your lordship did not pass an order. He will go and appear. For that, why a judicial order is necessary? If somebody needs a visa,
he needs the passport to submit before the visa authority in different country.
And he can go to the trial court and say that I'm going to Bangladesh. Kindly give me the passport. I will submit and give the itinerary and come back. For that, judicial order of the
I'll
High Court is
clarify
not
that
necessary.
position only.
My lords, every time he travels, my lords, my lords, he has to do a recce. For example, he wants to shoot a movie. He has to go to Singapore.
Scam is of 17.
See, every time you go,
yes,
you have to seek permission.
Yes.
What is the predicament is, for going abroad, you have to seek permission.
Yes, my lords.
And before going abroad, you have to seek visa. For that also, you need passport. So therefore, you have to virtually ask for twice. First, please give me visa. I'll apply. Please give me passport. I'll apply for visa. Then again surrender.
Yes.
Then while going again ask for permission.
Again,
that rigmarole.
Rigmarole, my lords. That is why I'm saying.
That is critical. So that I'll clarify. And he also doesn't have serious objections.
Yes, my lords. If the passport is released to me, my lords, what, my lords?
Passport should not be released. Passport will.
He says flight risk also.
Flight, my lords, I have my roots in Calcutta. I'm attending every time, my lords. CBI, they cannot arrest Nirav Modi. They cannot arrest my lords. Vijay Mallya. My lords, I become a flight risk when I appear.
That is the reason they are extra cautious. They have cut hold of you.
Charge sheet is filed on 22/5/2019 against the petitioner.
The petitioner has been granted bail by the order dated. Which one is the order?
My lords, Annexure 4, page 74.
74. By the Honorable Supreme Court, by order dated 30th November 2020.
My lord, I'm sorry. It's Annexure 6, page 91.
90?
91.
11/1/2020.
Right on. 11/1 to 90. 1 minute. Okay, 91.
21.
Right. The petitioner has been enlarged on bail by the Honorable Supreme Court by its order dated 11 January 2021 in criminal appeal number 27 of 2021. The Honorable Supreme Court, while extending the concession of bail, directed the court below to impose the condition as the fit and proper in the case. Accordingly, the petitioner has been, where is that condition?
My lords, page 99.
99. Petitioner has been enlarged on bail by the court below by imposing various conditions, including the condition inverted comma, he shall surrender his passport before this court and shall not leave the country without its prior permission. The petitioner has moved the present application under section 439 bracket 2 CRPC, seeking modification of the said condition. Mr. Milian Karungo, senior counsel, appearing for the petitioner, submits that every time he has to move abroad, travel abroad, he needs to seek permission from the court. He doesn't have any issue insofar as this condition is concerned. But what is the predicament is, before traveling abroad, he has to apply for the visa, for which he needs the passport. Therefore, he is agreed by the condition that his passport condition that the passport shall remain in the court. Mr. Sarthak Naik, learned counsel for the CBI, vehemently opposes the prayer of the petitioner and submits that the investigation, further investigation under 173 bracket 8 CRPC is pending. And
the petitioner in past has never cooperated with the investigation and even tried to derail the investigation.
Pending, and petitioner has never cooperated with the investigation, as a result of which the investigation is unnecessarily prolonged. Therefore, the conditions so imposed by the trial court should not be altered, and should not be altered. There should not be altered, as there is a flight risk involved in the present case as well. Keeping in taking into consideration the
Lordship also note that twice he has taken the passport and returned it. He has traveled.
Mr. Karungo also submits that
on two occasions.
Also seeks indulgence of this court on the ground that in the past, whenever the petitioner has traveled abroad, he has surrendered his passport immediately after returning to the country. Taking into consideration the submission made by the learned counsels at the bar, I am of the considered view that as and when the petitioner is willing to, going to travel abroad, he can in advance he can move application before the court below for release of the passport for the purpose of applying for visa and visa.
Write that word temporarily.
And when such application will be moved by the petitioner, the same shall be considered by the court below favorably without delay, so as to enable the petitioner to apply for visa and apply for visa. And after getting the visa from the overseas, from the country he wants to undertake the journey, the petitioner is also required to move a separate application seeking prior permission to
giving the
travel abroad.
Yes.
Prior permission to travel abroad.
And the passport can be immediately after coming back. The passport
and after undertaking the journey and returning to the country, the petitioner is bound to surrender the visa once again.
Passport.
Visa.
If that order is granted by the trial court may not leave him also. Your Lordship, if that order is granted by the trial court may reject his application also to travel abroad. So it should not appear as if trial court is duty bound to send him. Trial court may reject it also, your lordships.
No, on merit he will decide.
Yes,
That I am not saying
that line may
anything.
be added. The trial court will not be influenced by this court, will decide the application on its own merits.
If the trial court allow him to get the visa, after visa, how can the trial court reject it? It's the impractical proposition. Why unnecessary?
Well, I'm just.
There is a rider now. There is a rider that he has to move application and get the.
Immediately, yes. Well, I've just another prayer subject to what my learned friend says. There's a condition also. He shall appear before this court on each date of posting of this case. Malots, each date, Malots, because this case will go on indefinitely, Malots. Gautam Kundu and other people, they have still not been brought for
At the appropriate stage, you move the application. It is premature.
on each date, he is coming to sign in the order sheet. What I am submitting is, Malots, he is being represented through lawyer and he can appear through VC at, no, subject, because that's exactly what I'm saying.
You have a remedy under 205, you have a remedy under 317.
No.
You resort to that. I can't.
We will appear through VC also, Malots.
You move separate.
Well,
Yes. A free copy of the order may be provided.
It's a prayer, Achi, in this petition.
Insofar as the Mr. Kanungo or an constitutional petitioner submits that insofar as the other prayer in the present petition is concerned, he is not pressing at this stage. It's not pressing at this stage.
Your lordships may say that I've made a prayer
And seek liberty to move the court.
Move the trial court afresh.
Move the trial court at the appropriate stage.
Yes.
Yes.
Oblige.
Move up.
64. Oblige.
Item number 64, my lords.
Yes.
It's a transfer of billets. I have filed my Vakalatnama on 5/7/2023, my lord. Lord, my name is not coming, lord, and Jani Palini today in the morning, my lord and friend does. Home chamber on 5/7/2023, my lord.
Okay.
My name is Biswajit Naik, my lord.
Right on. The name of the land council for the petitioner, no?
For the petitioner.
Is not reflecting in the cause list. The name of Mr. Biswajit Naik, land council may reflect in the cause list. Least the matter.
Interim order, if any, my lord, may
Interim order.
65.
Yes, may I please, Lords, my lord. In this case, the present petitioner, the old father-in-law and married sister-in-law, before your lordship seeking the passing of the order of cognizance and the criminal proceeding initiated against them for the alleged offence under section 498A, 323,
Who are you, 74 years, mother?
The father-in-law, mother-in-law, I have not placed at the time of admission since there is one line allegation against the mother-in-law. But so far as the allegation against the father-in-law, there is nothing stated in the FIR, and so far the
Petitioner number 1.
Petitioner number 1, and the sister-in-law who is a government servant, against her is an omnibus allegations made by the informant.
Who is appearing for opposite party number 2?
I am for opposite.
Yes.
I'll take it. Time.
Interim order.
Interim order to continue at that.
Date may be fixed.
No, they.
66.
Yes.
My lord. My lord, in this case, my lord, the accused and informant, my lord, have already been filed the joint affidavit.
Where are they?
My lord,
Where are they?
my lord, opposite party 2, my lord, has gone to training, Hon'Ble training.
Let him finish his training and come.
My lord?
Let him finish his training and come.
My lord, joint affidavit already been filed.
They can't have that luxury of not coming to the court. Offenses are 420, 467, 471 and all. Where is the informant?
And in the meantime, I have been engaged, man.
Where is he?
Training huh?
Training.
Virtual recording.
Where is he? Let them appear in this.
Next date, man.
Give a date.
My lord, fixed any date, my lord. Eh?
24th. This month.
24. Virtual, virtual. Okay.
Pardon, my lord. Beg apology. 59, no, not. 59, I'm for OP. I held up my lord. 59, it is for the.
What happened?
And non-appearance.
Appearance. Yes.
67.
Yes, my lord.
67.
My
I
lord,
only.
my lord, this is my petition. Let me start.
No,
Sorry,
no,
my petition, let me start.
No, I'm not submitting on merit. Each time I usually resist the prayer for adjournment. But I pray, my lord, can it be taken up after 16th because of my personal inconvenience, my lord?
My lord, it is getting delayed, my lord, such a long time now, my lord. It's a limited issue, my lord. It will not take much of a time. Limited issues.
No, I'm bereaved. I hope you have taken 50, minimum 5 times time. I'm bereaved. I'm praying for after 16th and you are opposing
I
to
have
it.
not taken time.
Very unfair.
All right.
Mr. Singh, there is a
Very
bereavement in the family of the land senior council.
Oh, I'm so sorry.
So
I
he's
I
asking for
could not
that.
hear, my lord. Yeah, I'm absolutely not.
Yes. Okay. When do you want, Mr. Mishra? And
Only
Mr.
after 16th, any day.
Just see the dates are convenient to you or not.
Say,
After 16th, any day. Only
8, 9,
16th
9,
is
10,
13th.
my lord, sometime first week of May, my lord.
After 16th, you take why May? You can get it in the next week, 25th, 24th, 26th, like that.
But I'll just see. My lord, I'll
see?
just see. I'll just see.
In that week or 29, 30.
Every time, my lord, I take an attempt to come to Cuttack, my lord, I fail. So I was just trying to work out some date so that I can come and.
Then best would be 29. Monday.
Sir, I'll tell you, my lord, I have passed out from Ravenshaw College, and whenever I get a chance, I try to come there. But every time in this case, my lord, I am failing to come.
No,
So
therefore take a definite
if my
day.
learned friend will agree, I'll come.
Oh no, 29th. Mr. Mishra has no problem on 29th.
My lord,
I have no problem any date.
29th, Monday.
My lord, 29th, my lord, I'll not be a 29th April.
Lordship may fix it anywhere before that also. After 16th, my lord, any day you.
26th.
26th. My lord.
26th. Manas Kumar Kail, Arvind. 26th, my lord. I'll add.
But see, 26th being the last Friday of the month, there would be a risk. It may not reach also. That risk is there.
But in any case, I'll get a
Your
chance to
lordship
visit.
may take up on 26th, we will try our luck because your lordship has never always reached this item. Whenever it is taken.
Let it be 25th. Huh? 25th. 25th. Okay.
25th.
Yes.
Yes, madam.
Entry mode to continue.
Entry mode to continue.
68. May I please, your lordship? Lordship, the previous date, lordship give the direction to often. 68. My humble prayer because the grant of release of articles.
What is this matter is about?
The gone of the petitioner seized, my lord, by the forest authority, my lord. That has not been released in his favor, and the instruction sought for, my lord, that is kept in the seized gone, my lord, Riamal.
Submit that the gun in question,
my lord,
has been seized since more than 4 years.
Yes, more than.
And the trial.
Trial not, my lord. I have taken instruction today morning, my lord. Trial has not been concluded till yet, my lord.
Lordship, gone seized 8/9/2019.
But that has in, my lord, in the safe custody.
Near about 6 years.
Lord, I have.
The petitioner has no role in this case.
Armory while behind memo number 469 of 221, my lord.
Lordship, that petitioner has no role in this case.
They would have armory or rakha is safe custody rakha is.
Then what is your problem?
My lord, that is, my lord, the IO, my lord, mentioned that if the gun will be released in favor of the petitioner, my lord, may against the may my lord, the involvement in the notorious activities.
In this regard, the seized gun should not be released.
My lord. And when both the court below, my lord, rejected his prayer for my lord release of the
That is
gun, my
again-
lord, and the bullets.
That is that gun has no occurrence. The siege is the house. That petitioner is the license holder of this gun. And this
For
for
that reason,
the
both the courts below, my
protection
lord.
of his life.
Last order, in the meantime, call for the report from the learned James C. So-and-so regarding the stage of the case and the number of witnesses who have been examined with you. Mr. Pradhan, for the state, is directed to obtain instructions regarding the location of the registered arm.
Arbor
Dealer
Red.
located at Devgarh and Sambalpur.
Arbor Red.
It is Devgarh.
My lord.
It is Devgarh Armory.
Suppose se gone କିଛି ବ୍ୟବହାର କିଛି ମୋର କିଛି ସେଥିରେ କ୍ରାଇମ ରେ କିଛି ବ୍ୟବହାର କରନି
ତ ଆରାମ ଅଛି ସେଫ୍ କଷ୍ଟଡି ରେ କଣ
Arbor
କଣ?
Red.
ଘରେ ସେଟା ମୋର ଫସଲ କରେ
ଆପଣ have you seen this? Have you seen this report?
ସିଜର ସେଟା ନଷ୍ଟ ହେଇଯିବ
No, have you seen this report?
ତା part of iron and part of wood.
Asking something, have you seen this report? What the report which is given. No, copy the see
Sir,
that and address. Huh? Give a copy to pursuant to the order dated 29/9/2023. The a written report has been filed by the
I am giving the copy, my lord.
forest range officer, Remal Forest Range, which is taken on record. Learned counsel for the petitioners. It's time to study the report and address the court. Next week, address. Yes, next. 69. Yes. 69.
In fact, in 69, unfortunately, the conciliation has failed, Your Lordship. So I have to assist Your Lordship on the merit of the case. If Your Lordship permits me, may I only pray after 16 any day? Only after 16. I'm not praying for more than that.
The conciliation, the matter was sent to mediation. However, the conciliation has failed. Conciliation has failed. Mr. Mishra, Land Council, Civil Council, submits that he will address the court on merit. Please the matter. Please court.
And the interim order may kindly be extended, my
Interim order to continue.
will Your Lordship permit me one liberty?
Yes.
There is one item 103 that is against the state against conviction. I'll have to assist Your Lordship. My lord, I'm only praying if Your Lordship grants me 2 weeks time, I have to find the
103
party.
also. 103 note karo urgent karo. Okay, he'll urgent. Don't worry.
I'm grateful, my lord. I'm grateful, my lord.
60.
Item 70.
70.
That's item 70. Let the interlink matter is fixed to tomorrow, my lord. The lordship remember, yes, connected matter, my lords.
Connected matter.
Yes,
Please tomorrow.
tomorrow. Yes.
71.
I am appearing, my appearance may noted. I have instructions to appear on behalf of the informant in this case.
Both cases.
In this case.
Enter the appearance of Mr. Mishra.
71, my lord, one password.
Yes, sir.
70.
What passover? Urgent.
1160 59
71 urgent. At the request of
72.
72, lordship, pray for next week.
urgent.
on 72, there is an interim order. I pray it may be continued.
Yes. 70. Interim court. Interim to come.
73.
So item 73 and 74, notices in issued, nobody is inter appearance on behalf of the private OP.
He's attacking from place.
No, not taking notes. The chairs have been unsettled. I am appearing for 2 and 3.
Oh.
Deaf and dumb girl taken from the custody. He says submission was made if there is any prospect that he will marry or anything. There is no such thing, milords. His bad character, having no source of livelihood, no possibility. It's not a case of consent.
In both the matter.
No.
No. I am on 73.
73, lords.
Only 73.
Only 73. So
Then we
trial has
further
been
in-
stalled midway.
My lord, 73, I prefer any day, my lord. I prefer adjournment.
Already some witnesses have been examined. See nowhere says I was in law or anything. Even we have challenged that that interpretation has not been done properly before the magistrate while recording 164.
164 statement, there is some.
Recorded. No, she doesn't say voluntarily, but she doesn't say I was threatened or anything.
What happened in the statement before court?
Court, no, because of the stay order, both of them were there. Date was there last week. So interim order is there. They were not, she could not be examined. And we have also prayed for another interpreter because that has not been properly recorded. And she
He
said,
is already married, no.
no.
In temple.
She was forcibly taken.
No, my
Then
lord.
he exchanged a garland, said married you, kept her, rescued by police. Then
No, rescued,
statement
no,
was
voluntary surrender in
state-
conscience of the honorable court's order, my lord.
Statement was recorded.
Voluntary
In the
recorded the statement, my
she
lord.
said, I want to stay with my parents. I don't want to stay. That is there in the 164. So that itself suggests she doesn't want to.
Where is the court statement? Statement is not recorded.
No. She could not be examined because of the interim order. Trial has been stayed by your lordship.
My lord, since the loan council, the name of the loan council has not been
No, there
reflected.
is a problem. You said me that they
My
are
lord-
married, therefore the stay order is passed.
My
Now,
lord, next week, any
no,
day, my
what?
lord.
See,
My lord,
let the victim be examined by the court.
Yes.
Then we will come to know what exactly has happened.
Yes.
No issues, my lords. Your
Yes,
lordship may vacate the interim order, let it be taken after.
At least that victim should be examined. If the victim supports you in the examination,
Let it be
then
kept pending
you
here.
have a case.
Yeah,
I will
obvious.
be
my lord, next week I will satisfy.
No. So what satisfy? I thought they are married to save the marriage. Interim order was passed.
Father and daughter, I am appealing for both.
My lord, they have fled away and out of law papers, they have fled
She
away.
doesn't
my lord.
say that.
And stay
Come to
for
the court witness box and see that.
stay for 3 months, my lord.
Mr. Devasis Sadangi entered appearance on behalf of opposite party number 2 and submits
2 and
that
3, both. Father and daughter.
2 and 3.
Yes.
And submits that the victim, opposite party number 2, is a deaf and dumb girl. The petitioner has the petitioner she has not married with the petitioner.
Nor intends to marry also. Nor intends to marry also.
Intend to even marry the petitioner. Therefore, he prays for vacation of the interim order, so as to enable the victim girl to depose before the court. The interim order is varied. Interim order dated. Interim order passed by this court on 7/3/2012 is varied. Vacated, and the vacated and the matter is adjourned to such as day for hearing on its own merit. May pass with you.
Your lordship may say that the learned court will do it on priority basis. Immediately, he will give a date and examine. We are ready to appear. Court has to give a date.
It will not control unnecessary.
All right.
Unnecessary.
All right.
If the girl will support him in the witness box, then we can think
No,
of
then nothing. Obviously, it has to go.
Yes. So,
Urgent copy, my lords.
74 same. 74
No.
same.
Urgent copy, my lords.
74 what happened?
Sorry.
Urgent copy.
Your lordship, nobody entered appearance for the private OP. Lordship may kind of taken up.
None appears for opposite party number 2.
No name of the OP also not reflected.
Despite the service
Service sufficient.
Sufficient. Despite service in the interest of justice urgent.
75.
Mr. Interim order to continue. Lordship.
Entry mode to continue.
Problem.
Yes, 75 also notice has already been issued. Nobody is appear for the information.
Service agency.
Hmm.
Item delivered. Item delivery address.
Yes, sir.
Okay. Despite service, nobody has entered appearance on behalf of opposite party number 2 in the interest of justice, Sergeant 2. Entry order to continue. Entry order is there?
Yeah.
Entry order to continue. Yes.
78. 77. Yes. 78.
Yes.
Last occasion also was pleased to issue notice
Hmm.
on the on the accused. And Mr. Naik has appeared, but
Prasant Kumar Naik.
On behalf of Mr. Pikin.
yes.
You are appearing?
On behalf of Mr. Pikin.
Sorry?
On behalf of Mr. Pikin.
What do you want?
My lord.
You are appearing? You are appearing in this matter?
Yes, ma'am.
So what do you want? Adjournment?
So Mr. Naik was telling me he's not having the copy of the brief.
Okay.
So by
Give
tomorrow I'll show him a copy. Let's keep it. This we need even.
Take, give your name, huh?
Suman Mitra.
Huh?
Suman Mitra.
Suman Mitra, Learned Counsel for the petitioner, Learned Counsel appearing for the opposite party, on appearing for Mr. P.K. Naik.
Yes.
Seeks adjournment. Let the BC matter also.
Also 130 tenant matters. From 142 application pending ଅଛି 138 pending till let କିଛି ହେଇନି ସେ time ନେନି ଗଡି ଚାଲିଛି target ପାଇଁ ଆସିଥିଲି you'll also view that let him appear if it is possible can settle here that was the
But she is asking for
yes.
time.
No, I'm not on that. Let
She is
him
not
no.
ready even.
Yes. Keep it next week any day or else. Once it was
He'll give it. Yes.
79.
Alert, I am pleased, Your Lordship.
Yes.
Now, in this application, the petitioner seeks for quashing of criminal proceeding, my lord. On the ground that, my lord, during pendency of the criminal case, my lord, parties have settled their dispute and by virtue of a settlement, 13B have been filed and
Where are they?
But sir, I approve with opposite party number 2, my lord. Now, here the petitioner taking the aberment is that the matter already has been amicably settled, my lord. But as per my instructions, in the matter has not settled till yet, my lord. So
my lord, your lordship
personal
kindly.
appearance is not needed, my lord.
That personal appearance on 15/2/2024.
Oh, that
matter, my lord.
That lady.
My lord.
Said that the lawyer has taken 3
My
lakhs.
lord.
Oh, that's it.
Yes. Order number 2 dated 8/2/2024.
What to do?
My lord, I have paid, the petitioner paid, my lord.
But she says that
And she has, my
4
lord,
lakhs she has received.
your
3
lordship
lakhs
kindly
the lawyer
glance
has
to,
taken.
my lord, your lordship kindly glance to her evidence, my lord. She has stated in evidence in court, my
In
lord.
the ground of settlement, you want quashing.
My lord.
She says that it is not settled. I have not.
Madam, marriage has
What
been
can I
resolved,
do?
my lord. Your lordship kindly glance to the judgment, my lord. Pursuant to his statement, marriage has been resolved, my lord. And she has stated that I have received 7 lakh. And your lordship, the document has been exhibited in judgment, my lord. One, she has admitted in court of law, my lord. Thereafter,
No, you have
to
given
that
by-
respect, my
by-
lord, one, my lord, your lordship kindly glance to the judgment, my lord.
1 minute. You have given by way of draft. Check.
4 lakh draft, 3 lakh cash, my lord.
That cash component is taken by the lawyer. That's what she says.
That's cash amount is
If
disputed.
the lawyer does like that, what can I do?
My, she should have, my lord, already other forum is there, my lord.
Other forum there, I can't quash it. If this is the level,
But
why 3 lakh rupees was taken by cash?
as per her demand, my lord.
No, not demand.
But as per her demand, my lord. Your lordship, my lord, exhibit document that received, money received has been exhibited, my lord, and she has signed, my lord.
I can't. She comes to the court. In this court, she says that I have only received 4 lakh rupees. 3 lakh rupees is taken by the lawyer.
My lord, your lordship kindly glance to similar issue, my lord, on judgment, my lord, of apex court.
Why unnecessary? I have to pass some order against that lawyer who has done it.
Adjourn to any other date, my lord.
No, it's simply it has to be dismissed.
Not 2 weeks after, my lord.
Why 2 weeks?
I have
There is
to,
no settlement, finish.
judgment has been passed, my lord. Judgment, your lordship
Maybe she has
can.
to come and depose, na, in this court. I'm not bound by the trial court judgment. It is on the ground of settlement. She has to come and depose before, tell before the court that yes, I have settled. She comes to the court, says that I have not received money, I have not settled. What can I do? Can I quash it on that basis?
I will take instruction, my lord.
What instruction?
2 weeks after,
I call that lady here,
my
right
lord,
here.
my
She's a
lord,
doctor.
my lord. And
She's
petitioner
not
also,
a
both are doctor, my lord.
uneducated person.
My lord, to that, my lord, she has signed, my lord, and deported before the court, my lord.
Right, on the ground of.
2 weeks after, my lord, I will obtain instruction. What happened, my lord?
What instruction you will take? You tell me.
Lawyer, man, I will obtain instruction 2 weeks after. Also. These are the doctor, my
Can
lord.
you get back that 3 lakh rupees?
I will obtain instruction, my lord. Your lordship, Arjun, keeping 2 weeks after,
Do
my
you
lord.
know who is the lawyer?
But I know. I don't know.
The lawyer has taken money and.
I will obtain 2 weeks after. Also.
Otherwise, I will start an inquiry.
My lord.
Inquiry about it.
Bujhe instruction.
সেই গ্রাউন্ডটা নিয়ম সে 3 লাখ অ্যারেঞ্জমেন্ট করে তো দিয়ে দেবে
Your lordship, simple Arjun, my lord, I will obtain
3 lakh
instruction.
arrange kari de diyantu. Otherwise, see, I have to start an inquiry against that lawyer. How can he take 3 lakh rupees, which was meant for that lady?
My lord, that I do.
Do you want me to do that? This is very unfortunate.
That I do not.
Lawyers was not supposed to do all these things. 7 lakhs is the agreed amount.
My lord.
4 lakhs draft was paid to that lady.
My lord.
And 3 lakh rupees case and taken away.
She has admitted in court.
Do you want me to inquire it?
No, my lord. 2 weeks after also, I will obtain instruction.
No, next week. If you can arrange 3 lakh rupees, give it. Otherwise, I give a direction for investigation.
My lord.
She's a doctor. What are you doing?
Both are doctor, my lord. Petitioner also a doctor, my lord.
This is not acceptable. Next week, 16, you come and tell us.
No, 1 week after.
16th, 1 week problem. Instruction over phone only, you get it. 16, yeah, next.
81.
Better for you is arrange the money and give. So that I'll quash it and put a full stop. You are also a doctor. What is the problem?
I'm a pleasure, lordship. I'm on VC, I'm sorry. I'm on VC.
Yes.
Because of personal difficulty, I'm on VC. I met with an accident. I have challenged the rejection of my petition under section 167(2) CRPC. My annexure 1 page 14. Whereby court below has accepted the charge sheet as complete one without a chemical report. The IO has submitted the fact of the case is like that. FIR was registered on 27/3/2023. On the very day petitioners were arrested. Charge sheet has been filed.
Now whether the chemical examination report is placed on record or not?
My instruction that in the meantime chemical report has been filed.
Then
my instruction.
You have to apply for 439. This court has taken.
I am to submit. Here, charge sheet has been submitted. Submitted on 4/9/2023. After 161 days. Statutory period is 180 days. Thereafter, on 210 days, on 22nd/11/2023, I filed a petition under section 167(2) CRPC. The Lawrence court below dispose of the same on 13/12/2023 on the ground that the charge sheet filed by the investigating officer without the chemical report is a complete one, and it is construed as 173. My whole submission, the chemical the charge sheet without chemical report is an incomplete one. Therefore, my accrued 167(2), my rights accrued right from the
Mr. Swahi, Mohammad Darwaz matter is still pending in Supreme Court.
I am concerned. I have also filed
it will be decided. In the meantime, since the chemical analysis report has been filed, you file 439 on merit. You will get bail. You get bail.
What I submit, what I submit. When pending of the special, I am also filed the same, the larger bench decision.
I
That
know
is the-
many cases, interim orders are given.
Yes, my lord. Rakesh Shah, my lord, the state of West Bengal, Rakesh Shah, my lord, the division bench, the
Many
Soswar Khan,
cases.
my lord,
But our High Court, two different benches have taken a view that you
my lord,
go to the trial court and take
no,
the
my lord, recently, my lord, Honorable Justice, my lord, recently also,
Justice
he
R.K.
also, my lord,
Patnaik and Justice Shashi Mishra have separately and Justice Nursing also have taken the same view.
my lord, they have also taken the view that since court my lord, the accused has to accrue the benefit of 1672 since charge sheet has not been filed along with the my lord, chemical report. My lord, even during a hearing of the 1672 petition before the court below, the same was not filed, and after a lapse of around 1 year, my lord, in the meantime, chemical report has been filed. My whole submission, once the charge sheet has been filed, and I have not.
Yesterday only I pronounced a judgment. The same issue.
My lord, I am also, I have which
I am bound by, at least I am bound by my own view.
my lord, with much difficulties, I have, to assist your.
I'll pass the appropriate order. Huh? I'll pass the appropriate.
Deeply, my lord, my last submission, my lord. Besides that, my lord, petitioner is in custody around 1 year, my lord. 27/3/2023. Lord, considering all these aspects, 162 is the paramount. It's by
what is recovered? What is recovered from you?
Well, 44, that is 415 kg ganja, Milord.
Very
from a truck, Milord.
Anyway, I'll pass the order.
Milord, my written submission is there, Milord. My written submission is there. It will assist your lordship.
Yes, I'll take.
Milord.
82.
82, my lord, matter has been settled. Your lordship issued notice and informant is.
I am appearing on behalf of the opposite partner 2 and 3.
Both victim, no, posto is there.
Matter has amicable said.
Where are they?
My lord,
What are the offenses?
My lord, 3.
My lord, he is admitted in the hospital, my lord. He is in ICU and is in ventilator. So,
Who the
opposite part number 2, my lord. The complainant, my lord.
Complainant.
Yes, my lord.
Yes, my lord. 81 year.
Yes, my lord.
81. What are the allegations?
अरे 420 पैसा नहीं थले दे दीजिए
साइबर क्राइम रे पैसा
नहीं साइबर क्राइम में प्लेन अरे साइबर क्राइम में
My lord, let this matter be called after a month or.
Anybody is there from Chaudhary Pratap Kesari Mishra's son?
No, my lord. In fact, his son informed me in the afternoon, my lord. He's a learned counsel of this honorable court, my lord, as well.
Okay. Let it be on Friday.
Lord,
we learn counsel. Let him come Friday.
My lord.
Monday.
Let it be on Monday, my lord.
Monday.
I may be pardoned, my lord.
It will,
my lord. I may be pardoned, my lord. Item 81 that the government council is.
85.
That's why item 85 and 86 I prefer on adjournment.
What are these matters? Are you ready?
No, let's need some time to prepare a written note.
84. Learned counsel for the petitioner seeks time to prepare a written note and submit before this court. Let him do so by next week. Lease the matter on 23rd. 23rd. It is made clear that no further adjournment shall be given. No further adjournment. Both, Yes.
87.
87 may be taken up after 2 weeks, madam. After 2 weeks, madam.
What is this matter about?
That's in case of 376. I have required some judgment. And the medical jurisprudence is also required.
See, this matter was taken up for many times.
Yes, madam.
2023.
So
On the
taken up-
request of the learned counsel for the petitioner, the matter is adjourned to next week or 23rd, 24th.
24th. 24th.
It is made clear that no further adjournment shall be granted in this matter.
88.
Lord, 2 weeks time. We
What
don't know
is
whether
this matter is-
petitioner is alive or not.
Huh?
We have to connect with the petitioner. We want to take instruction.
Do you have any idea about this matter?
323, 326 hot matter.
323 only.
323.
Why don't you argue? Argue
Next date.
next week. Next week. And counsel for the petitioner, same order, 1 week time to prepare the case and file a written note. She may do so within a week. Leave the matter on such a, it is made clear that no further adjournment shall be.
89.
Maybe the lawsuit. Yes, offense under section 92 of the Factories Act.
Factories Act.
My lord. Sentenced to undergo SI for 1 year and to pay fine of rupees 10,000. Subsequently, appeal was filed, criminal appeal. SI was reduced to 1 month and fine of rupees 10,000 lordship.
10,000.
My lord. The allegation is under section rule 97(1) of Odisha Factory Act, petitioner is to inform about the incident which he failed to do so and has violated section rule 62B of
Provision violated?
violated rule 62B under section 41 of the Factories Act. He didn't inform the police about the incident. Since
That's the allegation.
my lord.
Nay, what are the sentences prescribed under it?
Factory Act. Factory Act 41B.
Factory Act under section 92 of Factory Act. What is prescribed sentence?
92, no? 92. Factory Act, the first time put you on. 92, my lord. Punishment is punishable with imprisonment for a term which may extend to 2 years, or with fine which may extend to 1 lakh rupees, or with both. And if the contravention is continued after conviction, with a further fine which may extend to 1,000 rupees for each day on which the contravention is to be continued.
Fine. Convicted to fine? How much? Because 10,000 fine is imposed, no? Let us make 25,000.
This is
25,000 fine.
But that may be given to the family member of the deceased. That may be given to
Under the provision, 25,000 will be given. Write down 25,000 penalty. Sentence modified to 25,000. Yes. Write down. Conviction maintained, sentence altered. Okay. Yes.
90.
My lord, can take now next week, my lord. We cannot contact with the petitioner, my lord.
The counsel for the petitioner submit that he could not contact the petitioner. Release the matter on such date. No further adjournment shall be.
Okay.
Yes.
91.
91 also I'm appearing through BC, my lord. I'm
Yes.
exactly not ready in the matter. You'll also call it next week. I don't know, not take further time. Next
I was thinking of appointing you amicus curiae in couple of matters. You yourself is not prepared in your own matter.
No. Here what has happened, suddenly it came up in the supplementary list. So I could not get ready because of some
Mr. Mishra submits that he is not prepared in the present case. So 1 week's accommodation is required. And let the matter be listed on 25th.
25th, my lord, and also 108. My lord. Item number 10.
Both the matters.
Both the cases. Next week, I'll
25th. Get ready.
oblige, my lord. Sure.
Yes.
92.
Non-appear, last occasion also non-appear. What rule? when the matter was taken up on 11/10/2023, none appeared on behalf of the petitioner. Even today, nobody appears for the petitioner. So and so is appointed as amicus curiae to assist the court. Please the matter, sir.
My lord, he is interested to conduct this case.
Yes.
Also, may appoint him as a-
Give his name. Give your name, take the and get prepared and come. You which date? 23rd?
25th.
25th.
Let's.
Get ready, huh?
Let's.
Details ଆପଣଙ୍କର mobile number ନା-
Mobile number ସବୁ ଦିଅନ୍ତୁ। ଠିକ ଅଛି।
93.
The same story here.
Yes, ma'am.
Who can that lady? What about you? Will you assist?
Are you ready?
She will assist to take her name. Appoint her as amicus curiae. Give your name. None appears to go. When the matter was taken up on 11/10/23, this item is item
93, madam.
93. एक मिनट 93 देखो when the matter was taken up by the taken up on 11/10/2023, none appeared and the last opportunity the matter was adjourned. Even today nobody appears. What is your name, ma'am?
Somananda.
Mr. Somananda, Land Council, who is present in the court, is appointed as amicus curiae to assist the court. Please the matter on
25.
25th. Take the paperwork and assist. Yes.
94.
May I produce?
Yes.
My lord, I want to be seeking your time, my lord. After 10 days, this matter will kindly called.
By way of last opportunity, the petitioner is seeking accommodation. Please the matter on
26. 26 half. 29.
29. Yes. Next.
95.
93 also against the confirming judgment, conviction under section 307 and SI for 2.5 years, fine approved to 1,000.
Then it needs
That's
to have
confirming appeal. You'll also keep it next week any day. Also go
Next
through
week.
the.
Next week. Get ready, you will finish.
As you know,
96.
Here also same story. Nobody appears. Same corridor. When the matter was taken up on 11/10/2023, none appeared. Even today, nobody appears. So appointed.
That's another person. Brother.
Yes,
Yes.
Mr. Please assist us.
Yes.
To give the name. Yes.
Item 96.
No. Amicus curiae.
Amicus curiae. 96. Item 96. Yes. And you tell me the date when you can be.
2 weeks up to.
Make it 29th, 29, 20. 29, 30. Yes.
97.
On behalf of Mr. Hon'Ble is praying for an adjournment.
Sorry?
Praying for an adjournment.
For no
The
reason.
brief is
Think of-
misplaced. Sorry.
Okay. Adjourn. Yes.
98.
98 here, the petitioner already died. That's it.
Petitioner died.
That's it.
Land Council for the petitioner submits that the petitioner in the present case
Get the 98.
98.
no more. Do you have the date? Died on?
Specific date we did not reveal.
He doesn't know. He is unable to inform the court regarding the exact date of death of the petitioner. Be that as it may, the petitioner is dismissed. In view of the fact that the petitioner died. Yes.
99.
When the non-APS for the petitioner in the interest of justice, urgent to next week the order. Nobody please. Next week dismissing the next.
100. Stated under section 307 and other offences, my lord. Arms Act भी अच्छी. Arms Act अच्छी. 307. Allegation against the petitioner is that, my lord,
Confirming judgment.
confirming judgment.
Sentence.
For 307, 4 years. And rest, my lord, 1 year, sentences are
Concurrent.
concurrent. My lord, here the allegation is that the police got an anonymous news that this petition is terrorizing the local people by holding a pistol. Police proceeded to the spot. He has hired towards the policeman, but nobody has injured. There are, my lord,
Nobody is injured. Where is the question of 307?
nobody was injured.
307. Mr. Rahul, what is it? No, just see, tell me the evidence. If anybody is injured, I can understand. If nobody is injured, then where is the question of 307?
And 2 witnesses, my lord, there are total examined more than 12 witnesses. The independent witnesses have not supported the prosecution case, for which, my lord, they have.
Who will support against you? You are so big terror.
Well,
Running in the street and threatening everybody. Nobody will support you. Forget about that.
that is the allegation of the police. FIR was registered by the police, no informant.
But fact remains that there is no injury to anyone.
No.
Then 307 is ruled out.
Ruled out.
Then what remains?
25-27 Arms Act. Seizure has not been proved. The seizure witness, that independent witness, the prosecution has not examined that seizure witness before the court.
Kali ko matter na revision to top lagaओ. At the top up to the revision matter. Just show me 2-3 evidences, we will finish it up. Now बहुत सारे matter.
No, all the witnesses who has supported the prosecution story, they are the police personnel.
Whatever.
And all the
Merely because they are police personnel, you can't discredit their.
No. Other independent witnesses who are also examined, not because, my lord, they have not supported the prosecution case.
Any doctor was examined?
Injury to doctor could examine.
That's what I'm saying. If the doctor is examined, then there is a chance of somebody might have been injured or something.
No, doctor का नाम ही नहीं है.
देखो तो 307 आने लगो. आपण टी एटा देखि दे. आपण टी देखि देबे 307 आसिले कोड जदी की इंजरी नाते किछि ना. No doctor examined, nothing, then what 307? Top रखिया को.
Arms Act में ना seizure is not in accordance with the law. जब seizure टा अगर prove हेलानी तो
seizure witness देखि देबा.
seizure witness का examine करना है prosecution.
ताले के seizure की prove करियो आपण. सेटा भी नहीं.
ना.
टिके देखि दियंतु मते आपण आछुती.
मु आगे खाली पढी दउची सेही पैराग्राफ.
आपण आसे दरकार नहीं कर दे. I will be there with you. Let them check it. Two things. 307 is ruled out because there is no injury, no doctor is examined. Arms Act 25-27 cannot be made out without the proof of recovery.
Yes.
These are the two issues.
Yes.
You just see if that is there, then entitled for acquittal. Simple. Then tomorrow.
101.
101, my lord. My name is there, my lord. But my name is deleted.
You
and
are
I will-
omnipresent, what to do? You are changing sides so frequently.
Ellen Patel and others name will remain, my lord. Arjun.
So, who is appearing? Who has taken no objection from you? Nobody.
No, Mr. Mr. Ellen Patel, others are there, my lord. Only my name
Okay,
will.
simply urgent and intimate them.
My lord.
Someone can ask another? I ask another.
102.
102.
102.
In this case, I will take instruction or short date.
No, this is the what?
This is against 130, against conviction under 138 NI. That has been affirmed by the appellate court, then
You are the.
I am the complainant before the law and trial court. I'll take instruction about compromise that.
No, I'll dismiss it. Because last time nobody appears. He's not bothered. 138 accused. Therefore, when the matter was taken up.
I pray, my lord. In fact,
Dismiss in your favor only. Why should you?
my lord, but in fact that 1 month prior to today, my lord, the local council told me that he has already received the amount. Only that part I will take in.
Tomorrow?
My lord, next week. I only pray next.
None appears for the petition. Even when the matter was taken up on 2/5/2022, also the petitioner had not appeared. Mr. Tell your name, please.
Yes, Harichandan.
Mr. Harichandan, then council appears for the opposite party and submits that he would be seeking instruction from his client regarding
Local council.
regarding the client regarding the factum of settlement in the instant case, and inform the court on the next date of hearing for the limited purpose of the obtaining instruction. The matter is urgent to keep it on 15. 15. Huh? No, only instruction. I'll dismiss it. 15. No, 16. 16. 16. Yes.
103 and 104 asked for adjournment.
Urgent.
105.
2 weeks after. 307 conviction, I am not ready, man.
Then council submit that he is not prepared in this case. Please the matter.
106.
My lord, on behalf of Tapas Kumar Acharya, kindly add them for 2 weeks.
May I please, Lordship? On behalf of my learned, I am appearing on behalf of the opposite party, my lord. My lord, this is a case under
A
section.
joint prayer is made for adjournment in the interest of justice, urgent to.
107.
Lordship, petitioner को चिट्ठी पठाई थी बट से डेथ बोली खाई आसी
हैं
चिट्ठी रिटर्न ही आसी जे डेथ बोली
Dead.
आगे
Who? Petitioner?
107.
107
107.
नहीं death है की petitioner.
आगे
There is a counsel for the petitioner. कौन चिट्ठी had placed on record a written instruction on record. Record. She submits that the petitioner has expired on. You have not opened also. Without opening, you know what is written. Right? ଆପଣ ହାଇକୋର୍ଟରେ ଫାଇଲ କରିଥିବା କେସର 3 ତାରିଖରେ ଶୁଣାଣି ପାଇଁ ଆସିଥିଲା। ଆପଣଙ୍କୁ ଆସନ୍ତା ସପ୍ତାହକୁ କୋର୍ଟ ଦେଖିଛନ୍ତି। ଆପଣ ଚିଠି ପାଇଁ ସାରଙ୍କ ସହିତ ସେବା କରିବାକୁ ଅନୁରୋଧ। ଆପଣଙ୍କ ଚିଠି ପାଇଁ କେସର ଫଳାଫଳ ପାଇଁ ଆମ୍ଭେମାନେ ଦାୟୀ ହେବୁ ନାହିଁ। এই মরিবার কথা তো কিছু লিখছেন
স্যার কিছু পরে আছে।
আমি লিখি টঙ্কা পয়সা ধরে আসো হ্যাঁ আচ্ছা you had written this letter which came with the endorsement he died huh
ଆପଣ ଏଇ ଲେଟରଟା ଦେଇଥିଲେ
ଆଜ୍ଞା
এই ଲେଟରରେ ଲେଖିଥିଲେ ଫିସ୍ ବି ଧରିକି ଆସ ମ୍ୟାଟର ଲାଗିଛି ସେ ଚିଠି ଗଲା ତାର ଡେଟ୍ ବୋଲି ଆସିଲା ବୁଝିପାରିଲେ ତ Learned Counsel for the petitioner provide a letter dated 8/11/2023 informed the petitioner regarding the listing of the present matter before this court. When this letter was sent through post, the postal department has written the letter endorsing the fact that the petitioner has already expired. The counsel for the petitioner is placing on record the letter with an endorsement of the postal department regarding the fact of the death of the petitioner. In view of the aforementioned, the petition will be dismissed.
109.
So after vacation, instruction নাই
Adjourn.
ছুটি সমস্ত
110. Hundred ten.
PK Patro. Last time, Mr. Patro has taken time to seek instruction.
Yes, sir.
Learned counsel for the petitioner, non-appears for the parties. Learned counsel for the petitioner on the last date of hearing, short time for seeking instruction. However, today, when the matter is called, nobody appears on behalf of the petitioner. In the interest of justice, adjourn to next week, 23rd, 27th.
24th.
Huh?
24th.
So today only one matter is that is 25,000.